This hearing is in regards to the case number CFI 088-2019 before His Excellency Deputy Chief Justice Ali Madhani. The claimant is represented by Charles Russell Speechlys LLP and the lead counsel is Mr. James Counsel KC. The defendant is represented by Baker Mackenzie and the lead counsel is Mr. Tom Montagu Smith QC. Thank you very much.
Hello, Mr. Russell. Good morning, Mr. Smith.
Good morning. Good morning, Your Honour. James Counsel KC for the applicants. Your Honour, can I begin just first of all by introducing everybody here? You've heard already that Mr. Montague Smith KC is representing the respondents. I'm representing the applicants together with Mr. Doherty, my junior. Your Honour, you will have seen from the bundle that there are a number of issues to be dealt with today. We have an application to stay and to adjourn, and with it an application, a privacy application. And then I suppose the remaining issues can be divided into two. There's what remains of the jurisdiction argument, which you heard argument on in March 2021 and gave your decision early in March 2022, and then there's the substantive pre-action disclosure application, and it may be sensible perhaps to deal with those two issues together. Mr. Montague Smith and I have had a great chance to have a chat about order this morning, and of course we're entirely in Your Honour's hands. We thought it would make sense for me to go first of all, obviously, on the stay application. And then it may be that Your Honour would want to hear from Mr. Montague Smith on that, or it may be that you'd rather that I carried on and dealt with all of the remaining issues, the jurisdiction and pre-action disclosure application, and then hear from Mr. Montague Smith at the end. We're really in your hands on that, Your Honour, which you'd prefer us to do, but it does seem sensible for me to kick off with the stay application.
Well, thank you very much for that. I think the sensible things maybe from my side is to deal with the stay. I start with you and then finish with Mr. Tom Smith.
Yeah, all right.
And then maybe short break, and then maybe if there is direction, because the stay would have an impact or consequences on everything, isn't it? Including the two other applications.
Exactly. Yes. Well, that seems sensible.
And the future of the proceeding between parties, I guess. This is how I understand it.
Well, that's really helpful. We both think I think that's a sensible way of dealing with it as well. So moving, if I may, then, Your Honour, straight away to the stay application, the documents. And
that's including the privacy. I mean, I would usually prefer like the privacy is at least dealt with. I mean, pre-hearing, maybe this is hearing, okay. If you both could agree like 2 days before, I mean, with the time that you're submitting skeleton argument, you could have written to the court about the privacy, so the court would have a better preparation. I've done this 2 times. I've done it 2 times before. I mean, one of them I've done it like freestyle like today, but once I've done it like just before the hearing, and I think it went well. So we managed to decide the privacy before, and then the hearing was fully prepared, and then the privacy was there, redaction was there, and everything. You know what I mean? Well, yes. So far you're still public until we decide the privacy, isn't it?
Yeah. Well, can I deal with that first of all?
But you go ahead. So the mic is yours. But I'm telling you, maybe for next time.
Thank you very much, Your Honour. Let me deal with that first of all, and it's a preliminary application, as you rightly say. It's I think not resisted by my learned friend, by the respondents, and the reason for the application for privacy is explained in Ms. Sheffield's 4th witness statement, which appears in tab 2 of section A of your bundle, paragraphs 57 to 61 at A212. As you will have seen from the papers, there is what appears to have happened here is that there's been fraudulent conduct on the part of a third party, or at least that's what the applicants would say. And we are perhaps justifiably concerned that any publicity of the steps being taken by the applicants, or indeed any publication which leads to further awareness of the fraud itself, may lead the wrongdoer to act in ways which further harm the applicants or their legitimate interests. We set out in the statements the steps that we're now taking to try to recover the position, and we obviously don't want those publicised greater than possible. So in the circumstances, the applicants seek an order that the hearing of the stay application, what you're dealing with first, take place in private pursuant to Rule 35.43 or 35.47 of the RDC. And as I say, the respondents have indicated, I think, in correspondence that they would agree to this or can see the sense of it, on the basis that the stay application sets out confidential and highly sensitive information regarding the applicant's corporate structure, their knowledge of fraudulent conduct and of steps being taken to rectify the harm caused by that conduct, and it therefore is in the interests of justice for that part of the hearing, namely concerning the stay application, to remain private. And as an addition to that, we request that that privacy order being extended to the evidence and documents filed in support of the stay application. So that would be Section A of the bundle. The parts of the skeleton arguments, at least, if not all of the skeleton arguments, which relate to the stay application. And of course, we've provided a skeleton argument which deals with everything, but I friend perhaps sensibly in the circumstances is dealt with separately, two separate skeleton arguments, and any issues or issued in respect of the stay application. So that's really our application, Your Honour, and I apologise that it hasn't been dealt with on paper in advance. We take on board the fact that you think it should have been. I don't know whether there's anything that Mr. Montague-Smith wants to add to that.
Well, I don't think I have not heard from you. What is the great interest you're trying to protect? What is the heavyweight things that would, keep us depart from the general rule, which is publicity or public courts or things done in public? You might have there is certain issue, there is a third party interest. So we're not talking about Russian-Ukrainian things in here. It's not nuclear powers. No? No, even that one dealt with in public. And that's it. If you have dealt with this before, we could have managed it before. But for now, this is a recording. If you might say some things to me, and if I disagree with you, that will still remain in public. This is the risk you taking with this kind of approach.
So, let me set out in a little more detail. Slightly hesitant about setting out the facts at this stage, but let me do that. The detailed background to the stay application is set out in Sheffield 4, if I can call it that, the fourth witness statement of Miss Sheffield.
Yeah, it's A2, page A3. I got it. Yeah. Exactly.
But I suppose as far as paragraph 18, and in Sheffield 5, the fifth statement at tab 5, paragraphs 8 to 16, and in the documents provided by her in the exhibits, which to an extent speak for themselves. On the 17th of August of this year, the applicants' legal advisors were advised by their clients that a man called Mohammed Al-Sari had used what was a cancelled power of attorney to effect an unauthorised change in the ownership and management of the first and third applicants to a company wholly owned and controlled by him called MAS Investments. That change in ownership affected the second applicant because the third applicant owned a shareholding in that company, but without going into detail, the true owners, if I can call them that, were able to thwart an attempt to change the ownership of the second applicant. And since then, the applicants have taken a number of steps to try to rectify the unlawful and fraudulent, we would say, attempts to misappropriate their companies. First of all, on the 23rd of June, second applicant effected a change in its ownership to remove the third applicant as its owner in order that it remained under the control of its true owners. The first and third applicants sought advice on the effect of the unauthorized change in ownership, made inquiries with the Dubai Economic Department, the DED, to ascertain how the change in ownership occurred, and took advice on that, both on civil law and criminal law, and commenced an action in the UAE civil courts in relation to the fraud. And there then followed court filings, which are exhibited, first of all in Arabic at A3, 58 to 62, so it's tab 3, the exhibit to Ms. Sheffield's statement.
Wait 1 second, I would like to see that too.
Yes, that's...
What's the page reference?
It's page 58 of A3.
So A58, the reference.
Yeah.
Yeah, I can see that. Yes.
And it goes on to page 62, I think. And there are, I think, well, I know that Joanna won't need to use it. There are translations to these.
Well, do you understand from this that, I mean, the change of this top management was done through a court order or something? So the intervention is not just power of attorney?
Yes, that's correct. There was a judgment, and Ms. Sheffield deals with that in her 5th witness statement. If you turn to A169, so tab 5, A169, she corrects an error in her previous statement, and she sets out there in paragraph 9. She says she stated that the change in ownership and control occurred because Mohammed Al Sari obtained a judgment in the Dubai courts in 2021, following which Mohammed Al Sari changed the ownership of the first and third applicants based on the findings in that judgment. And I think she exhibits a copy of that judgment to her 5th witness statement. And then she corrects that at 10. She says that the date of the transfer of the ownership of the third applicant following the issue of the 2021 Dubai court judgment was in fact the 19th of May 21. She exhibits the trade license. If you turn to back to tab 3, she has exhibited the trade licenses. Perhaps I could just
page
deal
number?
with. Yes, the one for applicant 3 is at page 72. That's the license before the change.
Yes. And the new one?
And then the new one is immediately following at page 74. And you'll see it's very difficult to read, but towards the bottom of that page, of page 74, there's a date. And if one magnifies the screen a little, you can see that it's the 19th of May 2021. So it's some time ago. Unfortunately, as she goes on to explain, and I was going to come on to deal with later, but I deal with it now, the applicants, perhaps not surprising, didn't realise the effect upon these proceedings of what was going on, which was why CRS, my instructing solicitors, didn't get to learn of it until August of this year. But that's perhaps a slightly different issue. Now, just picking up the chronology again, if I may, what happened next was that... So
one question before you just move on.
Yeah.
I mean, all that, let's say, the battles that over the ownership, whether in Dubai court or outside this court is in public, isn't it? It's public court. Well, I know there is not much publicity with the way the courts do its own business.
Yes.
Unlike this one, maybe, but still in public, isn't it? It's not protected.
Yes. And that certainly is.
And the proceeding already started, isn't it? So the fight is over. It's now, I mean, this fight is ongoing, I mean.
Yes, well, that's true to an extent. What we're anxious to protect is we don't want to publicise what steps necessarily, all of the steps we're taking to rectify the situation in these proceedings. At least certainly not at this stage, because Your Honour, of course, is right that the extent to which the public are particularly interested in some proceedings is limited, but there may well be interest that those involved in the fraud interested in what is said today in relation to this.
Well, it's very hard to take that. You can see, I mean, it's a legal process. You see its involvement, its applications, the court orders, and then you try to battle court and then stay. It's, I don't know. Might be a family, I mean, issues for ownership of the maybe collapsing empire. I said I have many cases and many applications related to this family so far.
Yeah.
But it's, you know what I mean? Well, but I didn't know, like, how privacy could serve any cause here. I'm still, I can't see what you were trying to protect, I mean, from anyone, you know. Mr. Counsel, I mean, if you just can be super specific, I mean, what are you trying to...
What we're anxious to do is to make as swift and effective progress as possible to recover ownership and control, if that's the right word, of these companies.
Right.
And
which you're already doing in the other courts, yeah?
Yeah, well, we don't necessarily want the fraudster to know that what it is exactly that we're doing and the steps that we're taking. It's quite simply that, and we are concerned that publication of these discussions and the steps that we're taking will or may have that effect. We're seeking to do what put right what is wrong in our submission, and it's a legitimate application in my submission to make in order to achieve that.
Mr. Magic Smith, any insight in this?
Well, we don't really take a position on this. I don't think it's correct that we agree with it, and we certainly don't agree that it makes sense, if I can put it like that.
Are you not interested, maybe?
I mean, we don't really have an interest in it, save to this extent. I mean, the claimant's coming to this court accusing a third party of some pretty serious conduct and trying to conceal those statements from that third party.
Well, say, apart from they trying to take it as a support of the stay application, Mr. Smith, I mean, you can talk about it, at least with the, limiting any scope of privacy. You will have your turn and attack the stay application. That's something for next.
Yes,
when it's come to privacy, well, you can.
Certainly.
From
no, but I mean,
fairness point of view,
my point is simply this: that my own friend makes some pretty serious allegations. His solicitors make some pretty serious allegations. We don't have direct insight into any of that, but that is used as justification for the application for a stay. And not only can we not test it because we don't have direct insight, but my own friend's asking for the record to be sealed so that nobody knows about what he says. Nobody who does know about it can see it and correct it. I just think, I mean, I'm not suggesting that it's being done for that purpose, but it's definitely something that the court ought to be quite cautious about. But in any event, I mean, it's not really a question for us in the sense that it's not our privacy that's being protected, so we don't take a strong position on it. But you know, as you say, privacy in this court needs to be justified.
Yeah, I see. Well, at this moment, I mean, councils, I would take a couple of minutes break and just to read some waivers. I'll go back to Ms. Sheffield. Fourth and fifth witness statement for a couple of minutes. And now we'll be back maximum in 10 minutes, maybe. I need 10 minutes, sorry.
Thank you very much.
I will need just to read something, and then I will let you know my opinion about privacy. Then we can go on with the stay application.
Thank you. We'll stay online while that's happening.
Yeah, you stay in line. Yeah, I just drop my camera and I'll be with you shortly. The recording is ongoing. Be careful. You're watched.
Understood.
Hello again, Mr. Council. Mr. Muslims. Well, from my previous reading and today's hearing and what I have just seen today, I do think that privacy is not justified. And we will go on to hear from you, your stay application.
So be it, John. Thank you very much. I wonder whether I could. It's mentioned in the skeleton, in fact, make an alternative application, which is that if Your Honour isn't with me in relation to that, that the order that should be published, it's paragraph 21 of the skeleton, with respect to the stay application, is anonymised in accordance with the DIFC Court's Practice Direction 3 of 2016, which allows for that in certain circumstances, so that
let's deal with it toward the end of your submission about the stay. Instead, bring it for
Certainly, I'll come back to that.
Go ahead.
So in which case, I've set out some of the detail already in relation to the chronology of events. Your Honour will see how we've come to where we are today, and what has happened in relation to an attempt to change the ownership of all three applicant companies, but in fact has actually only affected the first and the third. And the only thing that I didn't deal with, which I ought to in terms of the chronology, is that these proceedings are currently stayed, unfortunately, in favour of ongoing family court proceedings against Mr. Al-Sari. And although it's expected, hoped that stay should be lifted, I'm not instructed, I think, that it has been as yet. And so there will be, I'm afraid, a delay. Just before making my submissions in relation to the stay, might I just correct, if that's the right word, one or two of the points made by the respondents in response. Although the change of ownership has been known to the applicants personally for some time, the applicants just simply didn't appreciate the impact that might have on these proceedings. I think that's challenged by the respondents. They say, well, they should have done, they should have known that, and it should have been brought to our attention earlier. Whilst at the same time, in fairness, the respondents are saying, well, the change of ownership has no effect on these proceedings. And there is, with respect, something of a contradiction in that position. I do say the respondents can't have it both ways. Either there's not been a change of ownership, change of circumstances, as the respondents suggest, we say wrongly, in which case, why should the applicants have appreciated the effect upon these proceedings, this application, or there has been a significant change, as we would say there has. The reality is that until this was drawn to the attention of my instructing solicitors, there's no reason why the applicants, who are not lawyers, should have appreciated the significance on this application. But of course, that applicant would be, or we would say ought to be, obvious to the lawyers. And so as a result of that, they didn't let those instructing me know until mid-August. And since then, of course, it's taken a little time to make inquiries and for CRS to consider their position, to inform the respondent and make this application. And that perhaps brings me to the second point, which is that those instructing me are criticised for not informing the respondents earlier. Once Ms. Sheffield was informed in mid-August, as she explains in paragraphs 35 and 36 of her first witness statement, that's tab 2, page 8. Let me just bring it up.
Right.
Yes, at paragraphs 35 and 36. Plainly, this was a novel and slightly unique situation that had arisen. She had to investigate what had happened. She had to contact the DED, the Dubai Economic Department, seek advice internally and from external counsel in what were extremely unusual circumstances, and take urgent action to try to retrieve the situation. It suggested, I think, well, Ms. Sheffield was aware of all of this when there were 2 consent orders made. Well, with respect, all that first order did was to extend time for service of the evidence. It was to be hoped that this application would not need to be made. In fact, it has had to be made because of the stay, which has prevented us from retrieving the situation. Thirdly, in her witness statement, it suggested that some of the points that Ms. Sheffield makes are not from her own knowledge, and she doesn't make that clear. With respect, that's simply not so. In her statement at paragraph 4 of the 4th witness statement, she makes clear that the information that she sets out is set out from her own knowledge unless otherwise stated, as is the usual course. And where she is relying upon information from her clients, she makes clear that by using the words "I am instructed," which make it clear that it's not from her own knowledge. And in both her 4th witness statement and her 5th witness statement, she identifies the source of her information as being Mr. Majid al-Sari. By way of example, she does that in her 4th witness statement in paragraph 52, and in her 5th at paragraph 9. Just as an example, that last is at page 169 in tab A5.
Yeah, I see.
Fourthly, and perhaps it's a related point, it suggested that Ms. Sheffield's witness statement doesn't comply with the 2016 Practice Direction 1. That's in the authorities bundle. Again, that's not so. Ms. Sheffield is alive to the need to comply with that practice direction. She specifically refers to the practice direction in paragraph 12 of that, the first of those 2 witness statements, Sheffield forward, page 5 of A2. The evidence comes either from her own knowledge of events within the context of court proceedings, or it is to introduce documents which speak for themselves. And I've taken you to a set of those already, the licenses and the change licenses, and which demonstrate the purported change of ownership and the steps taken to recover the situation. And we've set out the court documents which have been used in order to try to do that. And we would say, as such, it complies with paragraph 2.1 of that practice direction, which you'll find, if necessary, in the authorities section of the bundle, section I, tab 48 at page 855. And the last correction, if I can put it that way, is this. It's correct to say that this application has now been ongoing for 3 years, but with the greatest of respect, it's certainly not the fault of the applicants that it has taken so long. Unfortunately, a year elapsed before we received the order after the hearing in March 2021. But leaving that aside, it was the 2nd to 4th respondents who caused a great deal of the delay by waiting until after the abandonment by the 1st respondent of its challenge to the jurisdiction in October 21, delaying making their juris challenge by 6 months for tactical reasons, we would say. The respondent itself made an application which was listed for hearing in October 21 and abandoned shortly before the hearing, and that itself caused delay. So setting that out by way of introduction, can I turn, if I may, to my submissions on the stay application? as matters currently stand, the management structure and resources of the first and third applicants are effectively under the control of a third party, placing the first and third applicants' legal advisors in what is a difficult and highly unusual and slightly uncomfortable position, if I may say so. Although they continue to act under the terms of engagement that have not yet been rescinded, there are obvious constraints on their ability to seek instructions with regard to the PAD application or the jurisdictional challenge. And it's just simply not right to say that my instructing solicitors can carry on regardless because the instructions have not been withdrawn. The current position is that Charles Russell Speechleys are acting for parties in circumstances where the current legal owners of two of the claimants are technically owned by a third party with whom CRS have had no contact and have no instructions. And just by analogy, not sure whether it's a good analogy or not, but may I make it? What if the claimants had been lawfully sold to a third party? Of course, CRS wouldn't be able to continue to act without receiving instructions from the new owner purely because the old owners had not formally withdrawn instructions. It does place us in a difficult position. And in addition to the recent misappropriation of the companies, and very much as a second, I stress very much as a secondary point.
Yeah, may I stop you here?
Yes, of course.
Mr. Constable, we understand, I mean, change of representation is not something, a battle to a proceeding, because I mean, you're in the courthouses for years now, you can see change of representation. Even if it happened, that doesn't mean it's the end of a proceeding. Well, even the new directors would continue with the interest of having this case decided in their favor, isn't it? It's a substantial money claimed in here. Why we think, whether your firm or another firm, could we continue? Well, see, I will go with you. Well, I will imagine there will be maybe an instruction of a new firm come in or whatever. But how on earth that would change the strategy of the claimants themselves or the company, the interest of the company toward this?
Well, with respect, Your Honour, we simply don't
know.
Well,
if they want to drop it, if they would like to drop the case, then it would drop. I mean, and that would not. That is the far end consequences. I mean, which is undesirable one. But if they want to continue, they will continue whether with you or without you, and that should not have a great impact maybe in the proceeding.
Well, Your Honour, you may very well be right, but our difficulty is we simply don't know because we don't have.
It's very difficult to see. It's not the firm interest, but it's the company's interest, isn't it? Saying continuing this proceeding, I would think we need to do different. We need to differentiate where you stand. I mean, I don't know whether you're defending your firm position or your client position with the continuous or the stay for the proceeding, Mr. Counsel.
Well, I'm obviously our principal purpose is to protect the client's interests.
Right.
But we don't have instructions from the technical.
Let's say hypothetical option with the client interest in the future of this proceeding. One could be continue with the same law firms and go on, isn't it? Then we got no problem.
That could be so, Your Honour. We simply don't know because we don't have instructions.
Okay, a third one, I would jump from the second to the third.
Yeah.
We have no interest in this proceeding, whether this council or another council gets dropped. So stay won't do anything with this, isn't it? Because the company decided not to go on with, they might think this is maybe a losing claim. I mean, a lot of cost. We didn't need it. We're not in a position to go in with that. You know what I mean? The banks are backing against us. Maybe it's a losing battle. We don't want to go on. It's gone. So option 1 and 3 maybe is not serving your cause. Well, and then let's take the maybe middle, something in the middle. I don't know if you can imagine something in the middle. Any other complexities that the claimants or the plaintiffs wants to do with this, where it's very difficult to counsel. Maybe they just want to continue with another law firms that come, or maybe recommended by a new in-house counsel. But that then will be another natural choice that happen almost every day in the courthouses. So, and if you have a fourth option, then I'm at your hand.
Yes, I suppose there is another option, which is if one tested it in this way.
That's what I want. Yeah,
yes. Yeah. If one tested in this way, if let's just hypothetically assume for a moment that our attempts to retrieve the situation were not successful, and so the ownership and control of A1 and A3, and who knows, possibly even A2, if that were to happen, passed to Mr. Mohammed Al-Sari. In my submission, if you were to proceed today,
it's already passed, I guess, and then you try to get it back. I guess that's what's happening, isn't it?
Then there'd be a risk in my submission that those new owners would say, "Well, we weren't involved. The claimants, the applicants, were not involved in that application. The people who were dealing with it had no authority to deal with it. They weren't, in fact, the claimants." And so there would be a challenge, or there may be a challenge to the validity of any decision that you made. And there is a risk in my submission in those circumstances that that we'd be back at square one, we'd be starting again, or there'd be litigation in relation to that caused by that situation. Now, I'm not suggesting that's a likely outcome, but I just put that forward as a hypothetical.
No, Mr. Counsel, I really don't understand this point because, well, you were being appointed by illegitimate directors, okay, at the time.
Yes.
The case pursued by illegitimate management at the time.
Yes. Yes.
Okay. And then change of directors or change of management. I don't know how can that would render my judgment. I mean, well, the way you describe, I'm still, I didn't get it. I mean,
well, then it may be argued that at the time that you made that decision, at the time that we are at now, heard argument, you weren't actually the application wasn't being made by the applicants at all, because those who control it, and this is in the hypothetical situation that we're not able to retrieve the situation, and therefore the hearing and the order that you made is invalid. I just use that as an extreme example of where one might be, because leaving aside whether or not in due course there may be a change of representation, that's really neither here nor there in my submission. That's not our concern today. Our concern is we don't have the authority. Technically we don't have the authority and instructions from those who, on the face of it, are the legal owners by a court order of applicant 1 and applicant 3. That's the danger, and that can only be resolved in our submission by a stay of these proceedings today, highly regrettably, until that is resolved and we can come back again. That's our submission in a nutshell.
Well, and maybe a wise judge would ask you, why didn't you write back to them and say, can I continue with this? You will understand there is a new management, and why didn't you seek instructions based on the new circumstances, Mr. Counsel?
Well, we're never going to get instructions with respect from our clients to write to the new ones and say, would you
could clarify, isn't it? You could have clarified the new position
with
the new management.
With respect, it wouldn't be appropriate for my instructing solicitors on behalf of their clients to write to those who are attempting to defraud them of their companies to seek instructions from that client. That with the greatest respect, can't be.
Oh, really. I see that difficulties. That's this one is I see it. Yeah.
It's an incredibly difficult and novel.
You're in one side, directors who's battling this to take it back. Yeah.
Exactly.
I see. And there is two class of cases, isn't it? There is a family one, and then there's civil court ones, isn't it?
Yeah.
So, and these two are connected,
Yes.
isn't it?
Yes, I think
And I think that the change of shares position is got two sources. One of them inheritance, and the other one is addendum to sale of shares agreement.
yes.
So yeah, so it's a bit complicated. So you think the stay would go for how long?
Well,
from your experience.
I'm afraid I don't know the answer to that. I mean, we're attempting to have the stay lifted now, so it's to be hoped not very long. Obviously, we are anxious to bring back this application as soon as it possibly can be, because the last thing we want is for it to be delayed further. But in my submission, then there really does need to be a stay and the consequences of that, because we simply don't have instructions from technically the legal owner of these two companies, and we simply can't act on the basis that we do from the second applicant. That leaves the third and the first in sort of limbo. Can I just expand a little bit? And I'm conscious that you will have read the skeletons. I'm really at paragraph, I think, 26 of my skeleton. I make the point the court has a wide and unfettered discretion under Rule 4.2 to order a stay of proceedings, but the relevant circumstances in our case are these in our submission. The steps taken by a third party to defraud the applicants, and that's strong language, but that's the applicant's position, are exceptional and have arisen through no fault on the part of the claimants. And this is, in our submission, one of those, to use the words in IGPL and standard charters, it's paragraph 68 in tab 5, paragraph 74 and 76, one of those rare and compelling cases where a stay is required. Indeed, it's difficult to envisage, we would say, a more exceptional set of circumstances justifying this application. And the effect of the conduct of the third party is prejudicial to the applicants, because it affects our ability to take instructions. And it follows that if this application proceeds today, then we would need to make it on behalf of the separate applicant only, and it would, in our submission, make no sense at all to proceed to hear the case, but only insofar as it affected the second applicant. That might need a further hearing in due course, which would be crazy. And there is a legitimate public interest, of course, in proceeding with applications whenever one can, but it is submitted that the interests of fairness plainly outweigh that important case management consideration. These are pre-action applications rather. So it isn't as if this vacation of this application would lead to other dates being lost, particularly a trial date, nor, of course, would the work that's been done to prepare ourselves for this application be wasted, because in due course this application will need to come back as soon as these issues have been resolved. And I make the point that compared to the value of the claim, which the applicants put at approximately 100 million dirhams, the cost of staying and adjourning are relatively minor, although of course it's highly unsatisfactory to do that unless it's necessary. And given that this is an application for pre-action production, therefore the respondents are on notice of the documents and evidence that needs to be preserved. In fact, we know that helpfully the respondents are already taking steps to collate and organise their documentation, and a delay of what we hope will only be a few months will therefore have a relatively small impact on the availability of evidence at trial. And so for Your Honour, for all of those circumstances, in the particularly unusual, almost unique, I've not come across this before, circumstances of where we are, I do invite you to take the view that the potential substantial prejudice which would be involved in proceeding with this application in circumstances where the first or third applicants can't provide instructions and we can't take them, or even confirm their authority to proceed, far outweighs any prejudice to the respondents, indeed to the parties, and the stay application should be granted. Your Honour, those are my submissions on the stay, unless I can assist you further.
Maybe you can further elaborate on cost of the proceeding if the stay is not granted from both sides, maybe, especially if we abridge the jurisdiction, if I mean the pre-action disclosure is granted, it's substantial. It's going to be substantial cost, isn't it? Without knowing, I mean, having a full, clear view of the future of this firm and maybe even the proceeding. Yeah.
Yes, well, I touched on it already. Of course, a lot of the costs would assuming that this application comes back, let's say in 3 months' time, or 6 months' time, whatever it may be, a lot of those costs would have been needed in any event. A great deal of the costs of preparation and so forth. Now, except, as will no doubt be said, that there will be some additional costs, because of course there'll be the costs of the further hearing and the costs wasted today, and that will no doubt be a matter which will need to be decided upon by the court in due course. In my submission, it would be inappropriate to do that at this stage, but there would obviously be some costs, some wasted costs, and that will need to be dealt with in due course. I'd prefer, if I may, to deal with costs once decisions have been made, and indeed perhaps once we come back again to hear this argument, so that we know how we'll then be in a better position to know what costs would have been incurred in any event. But there are inevitably going to be some wasted costs, and it's highly unfortunate that that's the case. But there are always costs in relation to.
Okay. Well, another option, I mean, to elaborate on cost again, and while we're still in this point, knowing that you already have filed a claim form a couple of months ago, and you still insist to call this as, I mean, pre-action proceedings. So we maybe, as Mr. Smith had elaborated in his defense, well, maybe it's not anymore a pre-action. I don't know. We haven't decided yet. Yeah, we understand this application is started a while time ago, before the claim form being lodged. Well, maybe you can cut this hassle, and while you drop this application, and then while you have a claim form in the ground, you drop this. Maybe you can agree with the other parties that. So, well, there is an agreement, I think, maybe in place, and to deal with the claim form to extend the time for submission and regard of that claim form, and then cut things short. I don't know. It's speculation.
There's currently a standstill agreement in place. And I'm getting ahead of myself a little bit, but there are in our submission, there we'll deal with these points in due course. Good reasons why this should be dealt with effectively as a pre-action disclosure application for example, because we say it will allow us properly to determine which are the correct parties, and properly to plead our case and so forth, and so therefore to deal with it in due course by applications for disclosure in the normal course.
Did you just said you need to know who is the correct parties?
No, we make the point in our submissions that there's always the possibility that the disclosure might lead us to suppose that that some parties or others may not be necessary, but we're not in a position to do that at that stage. That isn't making any concession as to who are the appropriate parties at this stage, but that's perhaps for later submissions. We do say that the appropriate course is for this application to be adjourned, and for there to be what will hopefully be a short stay, in order for the position to be retrieved and then the application to be made in due course. And if I may say so, it can come back before Your Honour, then that will in itself no doubt involve a saving of costs, because it won't involve the court in having to start again with a different judge.
Well, let's see. I mean, if there is any stay, it will be depends on what, like another finding, a judgment Dubai court, family. I mean, if there is a stay, I mean, it just a stay without. I mean.
Well, it certainly isn't intended to be an indefinite stay, as is suggested. We need to get a court order which covers ownership of the first and the third applicant from those who've taken it over, and proceedings are underway. Unfortunately, because they've clashed with family proceedings, they've currently been stayed. We need to obtain an order lifting that stay so that we can proceed with that application as soon as we can.
Actually, it's a similar one. Well, let's turn to the other side. Let's hear from Mr. Montague-Smith what he think.
Thanks, Your Excellency.
Your stay application.
Yeah, so obviously we oppose the application for a stay. I mean, my own friend accepts this is a highly unusual application. We do say that the claimants are trying to put off the pre-action disclosure application indefinitely. They object to that description. My learned friend does it again today, but that's precisely what it is. They say this claim has to go off until some date in the future, which we can't now specify. And indeed, the draft order simply says it's stayed until further order. So we are talking about saying this claim just is suspended. That's what indefinite means. We say the explanation for that application is wholly unsatisfactory, and it creates the uncomfortable feeling that we are not being given the full picture by the claimants about what really is going on here. And I'm afraid that my learned friend's submissions today rather add to that confusion, because he has been extremely loose in his explanation of the facts just now to you. So what was suggested to you in submission just now, for the first time in these proceedings, was that there might be some question as to his authority to act. So you'll recall that he postulated a concern that somebody might come back later and say he was not authorized to act. That is not what his evidence says. That has not been his case up to now. He said up to now, there might be some constraints in his getting instructions. And we don't accept that that is fully evidenced at all. But that is quite different from saying that he's not authorized to act. To be clear, his evidence doesn't say that. His evidence says he is authorized to act. It says the opposite to the submission that was just made. Now, that evidence, and this is a general submission about the quality of the evidence that's provided in support of this application, that evidence is provided by Miss Sheffield, who's a solicitor acting for the claimant. She has no knowledge of the facts, no direct knowledge of the facts. She says she does in her evidence. She says she's stating facts about these proceedings, but she's obviously going well beyond that in this case, because she's talking about the fact, for example, that there's been a fraud by which ownership has been changed. She can't possibly have insight into that. And importantly, she gives evidence about when the claimants knew about these things and why the claimants failed to bring this up for months. And she cannot possibly have direct knowledge about that. And she says throughout her statement in support of this application, I am instructed. And recently, we've discovered that the information she passed on is definitely incorrect. So I don't know if you've seen this, but in her first statement, she said that her clients found out about this change of ownership in, quotes, June or early July. That's paragraph 35 of her second statement. A fourth statement, sorry. Now she says, well, the transfer in respect to the third claimant happened on the 19th of May, 2021. That's a year and a half ago that this change in ownership happened. And then she says that paragraph 11 of her fifth statement, that the applicants became aware of it at some point in April 2022. So not June, July, but April 2022. and they don't bring it forward as an application until October. So even now, the evidence is entirely vague at some point in 2022. But the effect of this is quite vague as to exactly what the effect is. But the effect of this, it is said, is that a third party took control of the management and resources of the companies, such that it's now impossible for them to continue, or that it's very difficult for them to continue with this application. And there's no explanation of how that sort of change could just simply not be noticed for a year and a half. And there's no explanation even now for why we were told something that was wrong. June, July becomes April. What you would expect, and in fact what is required by the rules, is a statement from someone who has direct knowledge of this. Now, Your Excellency is familiar with the practice direction. You weren't taken to it, but it's in bundle I at tab 48. And there are narrow exceptions to the rule that a solicitor should not be giving evidence on behalf of their client. And those exceptions are in paragraph 2.1.
You said I-48, isn't it?
I-48, correct. And so the general rule is that paragraph 2.1, as a general rule, law firms are representing a party through part 1 of the Register of Practitioners in proceedings before the DIC court should not permit lawyers who are employed by them to file witness statements in such proceedings unless the contents of the witness statements are formal or uncontroversial. Well, that doesn't cover this. Or the witness statement has been submitted solely for the purpose of introducing documents without any factual evidence being given with regard to the merits of the case. They can give their own, and then it goes on to say they can give their own personal knowledge of events happening within the context. So that's and Your Excellency will know about the Sky News Arabia case. We refer to it in our skeleton argument. We don't necessarily need to go to it. The problem is not the one that my learned friend said I was complaining about. I'm not complaining that Ms. Sheffield doesn't identify the source of her information. In fact, she doesn't do that consistently. She does sometimes, but sometimes she doesn't. The problem is that the evidence can't come from her. There's no admissible evidence in support of this application, other than the documents that you've seen.
There is a document we have seen. There is.
Correct.
We've seen the license. We've seen the particular of a claim that's lodged to the Dubai court.
Yeah.
And
Beyond
we've
those documents,
we've seen her say some instructions direct from a client, and then they see the instructions from the client too. I mean, well, we might not take it all, but we shouldn't drop it all as well.
Yes, but the documents is what you can say. So what we can see from the documents is there's been a change of ownership. Now, a change of ownership in and of itself is completely irrelevant. It's completely irrelevant.
So you're saying fraud is not approved? It's not the change of management.
It's not just the fraud. It's not just the question of whether there's a fraud. If a company changes ownership, unless the management itself is changed in some way, then the same directors carry on. Companies are traded all the time, and it's the directors who give the instructions. And in terms of authority, there will be ongoing mandates that are already out there. So solicitors are appointed, whether it's under a power of attorney or under a contract or whatever it may be. They're given the authority by the company, and that authority continues until it is cancelled. And it hasn't been cancelled. That's the evidence that you have before you. And so then all you've got is, well, the evidence is important about when the claimants knew and why they didn't tell their lawyers, and there's that evidence just has to come from the claimants themselves. It can't come from their lawyers. So just dealing with it in stages, there are 2 stages that Your Excellency has to consider in this application. The first is the consequences of the delay, and then the second is whether, because we say the consequence of the delay and they're agreeing to directions is that it's not open to them to come back and try to reopen those directions, because nothing has changed since those directions were made. If I'm right about that, that's the end of the application. And then the second stage is, all right, if I'm not right about that, are grounds for a stay made out in any event? Now, As to the first stage, the particular problem that the claimants have is that they agreed directions on the 14th of July and on the 2nd of September. And we say the effect of this application is to try to revisit those orders. So let me show you, if I may, those orders. You'll find them in bundle G, tab 29. Sorry, page 29.
Consent order, yeah.
So you'll see the consent order, and if you go over the page to page 30, you will see paragraph 1 sets out the directions for the listing of this application. And so it's quite, and so there's exchange of evidence, and then step 1E, listing the application in that window. That is an order that was made on the 14th of July 2022 by consent. And then the next order is at page 31, and you see page 32, that is dated the 2nd of September. And you see there's a revision of the deadlines for the provision of evidence in there, and that's agreed on the 2nd of September. Now, the effect of this application is that the claimants want to tear up both of those orders. And if they want to do that, they have to show a material change in circumstances since those orders were made. That's the effect of Your Excellency's decision in the Vanin case. And the Vanin case you will find, and I'll just show you 2 paragraphs of that.
Yeah, Mr. Smith, I mean, that can be right, but I mean, let's say when the Mr. Counsel said they've been instructed by the 17th of August about this, maybe to them a dramatic change of ownership. Even by 2nd of September, isn't, I mean, it's a matter of 2 weeks.
Yeah.
What I would imagine, I mean, well, first of all, maybe they need to bring in evidence. How serious is that, and what impact is doing? What's the how the directings? I mean, feeling about it. I mean, maybe extra internal evidence. But I would think 2 weeks' time is, and the lack of instruction would cause a lot of ambiguities, you know, around the proceeding. I mean, I would imagine. Yeah.
There's 2 questions, aren't there?
Mm-hmm.
The first one is, what about the delay between the claimants knowing about this in April and taking it to their solicitors in August? What about that delay? Does that delay actually explain anything? Does that assist my learned friend? Because if it doesn't, then you just have a situation where the claimants have agreed to directions in the knowledge of the facts that we're discussing. And the question that you said was important in the Vanin case was, and I'm quoting, were the facts known to the claimants or the parties, or could they reasonably have been known to them when those orders were made? It's not for this court to investigate the interactions between the lawyers and their clients and try to work out what was the reason for the actions. The point is that they were represented. The point is that they knew the facts that they rely on now, and they didn't bring them forward to this court, but instead they went on and agreed directions, which we complied with at great expense, and only brought this forward after that had been completed.
Well, Mr. Smith, this is not an urgent application. We're not deciding urgent application. This is an ordinary application. Okay, was filed and lodged and submitted and respond to in the usual times of ordinary application is meant to deal with the future of this proceeding. So urgency and that kind of matter shouldn't be. I mean, it's better, I think, to focus whether the stay would be a better solution for the current situation or not, instead of, I mean, deciding when they come to know. Let's suppose they come to know very late. Maybe they were negligent in knowing. Let's go to the extreme. Okay, let's defend the claimant case more than what their lawyer tried to do. Okay, let's forget about the bad. we have a situation. The situation, let's say we were told, going to have an impact in this proceeding, and maybe the consequences would be that's dramatically bad to this future. So what's the best way in dealing with this? Costs would involve, you know, change of management to understand owners can have sort of influence, maybe own directors, you know what I mean?
I understand.
I wouldn't know, but that's what I said. I mean, just I'm sure maybe that would be your secondary point.
That was my second point.
Let's take it all together.
That's my second point, and I'm coming on to it in just a moment. But let me just put this proposition, which is that my learned friend says I want it both ways, because his explanation for the delay is that his client didn't realise the impact on this claim. But my point is, either there's no real impact on this claim, and that would be consistent with the claimants not realising, or alternatively, there is a genuine, serious problem with the management of these companies, in which case it would have been obvious from the date way back in May 2021. So mine is an either or, whereas his has to be both. Because if he can't explain away that delay and say that something material happened, then we say it's abusive for him to come back and try and revisit these orders. So it's not me. I'm not saying I can have my cake and eat it. It's precisely the opposite. He has to both persuade you that it causes a real problem and justify the delay. But it does go to the second point, which is the one that you've asked me to focus on, and I will focus on it. Because the fundamental complaint is that the ownership dispute is somehow interfering with his ability to present this application. Now, I accept this is not an urgent application, but there are reasons why it needs to be dealt with expeditiously and with due speed. Because, and I'll come on to those in a moment. But fundamentally, you need to be satisfied, because an adjournment is an order of last resort. You need to be satisfied that this really needs to happen. But quite how it's interfering is not really explained. And then we have this development of the position in submissions. Because the way it was put originally, and the way it's put in my learned friend's skeleton argument, is, quotes, that the management structure and the resources of the company are under the control of a third party. What is meant by the management structure is very unclear. That's very vague. What is being said? They don't say in terms that the directors have been changed by the owners. They just say, and they don't say that that is having any kind of impact on their actual authority, although that is a submission that my learned friend appears to have been making. What they say is that there are, and this is the submissions, constraints on their ability to seek instructions. Now that is not supported by the evidence, and that is totally vague. That is insufficient. That's assertion. There's no explanation of what those constraints were. As I said at the outset, a change in ownership is irrelevant unless it affects the people who are in control of this piece of litigation, whether they be the solicitors or the people giving the human individuals giving those solicitors instructions. And it's not even said that those directors have changed. The evidence is quite the opposite of what my learned friend said it was. So if you go, please, to Bundle A, tab 2, page 9. This is the beginning.
A9, you mean? A9?
Page 9, A9.
Ah, page 9, sorry, yeah. Oh, I'm sorry. And the fourth witness statement of Ms. Sheffield?
Correct. This is Ms. Sheffield's evidence on the effect, the impact that this is having on these proceedings. So we'll go through it. 42A says this firm continues to act on behalf of the first and third applicants pursuant to its terms of engagement, which have not been terminated by Mr. Mohammed Al-Sari or any representative on his behalf. So her position is that they remain authorised, and therefore that Mr. Counsel remains authorised. And so that suggestion that there might subsequently be some argument that they are not authorised has absolutely no basis in fact. It's just speculation by my learned friend and inconsistent with his evidence. And then they say, B, the true owners of the first and third defendant applicants are unable to take any further steps in this litigation as control of their resources has been assumed by Mohammed Al-Sari. So B, actually, the allegation is not that they are not in a formal position to give instructions. The allegation is that because they don't have the claimant's money to run this application, that is the problem. But they clearly have money from somewhere, because my learned friend has been paid to attend. I'm sure he's not doing this pro bono. And so even if, for whatever reason, there's a bank account somewhere that belongs to the first claimant, say, and it's been locked and they can't get access to it, they still have resources to fund this litigation to today and to argue this application today. So nothing interfering practically with this. And then point C is simply it's unclear on what basis the respondents consider that these proceedings could continue. Well, that's not a case for saying there's any real interference. And throughout that witness statement, Ms. Sheffield states, I am instructed. I am instructed. So presumably she's being instructed by the same individuals as she was before. There's actually no evidence whatsoever of any disruption in the way that this application could be advanced. And this feeds into the point that I was making about this new date that we have for the third claimant's change of ownership was back in May 2021. If they didn't realise any impact on the management of the company for 18 months, or a year it was, from 2021 to April 2022, then how real can this disruption actually be? So the bottom line is that my learned friend's here to make the application. Ms. Sheffield's making other applications on behalf of the claimants. They're in a position to advance these applications on behalf of all of the claimants. And they said, in fact, that they intended to file further evidence. They sent an email saying, well, we're going to put in some more evidence. They didn't actually do that in the end, but they clearly could have done that. And we know that the point about funding just isn't real, because here we are. There was another point made about witnesses, the availability of witnesses, and my learned friend doesn't press that today, but there was a case that a Mr. Al-Zubi wasn't available because he was in Jordan, and that somehow somebody couldn't just take the documents to him or send the documents to him, and it had made all the difference that he be in Dubai. That's another excuse that really undermines the credibility of this whole application, in my submission. And then the other point, so as to actual disruption, and that's the meat of it, that's what you were asking about, that there's really no evidence of it. And so my learned friend has to go to the extent of insinuating that there might be a problem with his authority, which has never been suggested before. That's the first time anyone has ever said that, but it's inconsistent with the evidence. My learned friend made points. He said, oh, well, none of the delay in these proceedings is the fault of his clients, and it's all down to my clients. I suggest that's a remarkable submission, because in November of 2020, my clients offered to have jurisdiction and the merits heard together in a single hearing. And the claimant said, no, we don't want to do that. And that, frankly, has been the cause of most of the delay. That was, we made that offer on the 5th of November, and the defendants and the claimants just simply refused it on the 11th of November. So to suggest that there's no delay that's been caused by the claimants is just simply wrong. And then even after Your Excellency's jurisdiction decision came out, the claimants did absolutely nothing. And in the end, the court had to write to them 3 months after that judgment and say, tell us whether this is going forward, or we're going to close the file. That was the email that was sent by the court, the reason being that they had done nothing to move this forward. And now they're saying, oh, well, actually, let's put this all off. So the reality is there has been considerable delay on this case. A lot of that is down to the claimant's choices and refusal to bring this forward. Some of it isn't their fault, but a lot of it is. We say none of that is our fault. Now, a delay in the past is a powerful reason to ensure that going forward, this claim moves quickly. And the delay in notifying the court is another powerful reason. If it doesn't exclude the application entirely, which is what I say, it's another powerful reason to push this forward fast, not have this go on and on and on. So this pre-action disclosure claim has been on foot for 3 years. My clients have been on the hook for all of that time. And then in relation to the new set of proceedings, there's a standstill agreement. So until this application is determined, limitation just continues to run for as long as it takes. Now, obviously, we didn't expect that limitation agreement to be indefinite, but that is the effect of putting this application off. By the time this comes to trial, if there is
that risk for the claimants too.
Yes, you're right in that in one respect, but it's a risk that's taken in the knowledge of the court rules that an application of this sort is granted as a matter of absolutely the last resort. And so we say a strong reason to keep the parties strictly to the rules and not just give latitude, because one turns up and says, well, we've got some difficulties, can't really tell you what they are, but we're having difficulties getting instructed. The claimants have asked for documents from 2013 in relation to this case. So they say that facts that happened back in 2013 are relevant. By the time this comes on to trial, we'll be a decade past that sort of date. And there will be significant wasted costs if we adjourn this off. And there will be significant waste of court resources. So, and we say that there are some very short answers to this.
And sorry, but how can that have impact on you? Because whether it's this application or this case is heard today or tomorrow, it's going to be the same cost, maybe.
No, because if we don't go ahead and hear it today, and we have to come back in a year's time, you know, I'm maybe my learned friend is different from me, but I will have to read back into the case, and maybe there's no further evidence to be done, but everybody will have to read back into the case, get prepared for this hearing again. There will be considerable wasted costs as a result of having to come back.
Yeah, but well, anyway, I mean, you've been notified by this. You could have agreed to it before, but now it's you leave it up to the court to decide it. So this is one kind of risk you're taking.
Yes, but it is a material consideration for Your Excellency in determining whether or not to stay. You obviously don't just grant a stay and adjourn off a hearing because a party asks for it. And one of the factors that you have to consider is what is the consequences of that. But it's not the only one.
And this is one of the questions I'm asking you about. What is the consequences on your side?
The consequences
if they're asking for a stay, we shouldn't look at the impact on their own, but well, this is an interest of another parties on the proceeding is to be questioned, and this is my question to you. Well, you might say a further reading. You mean you need to be grapple with the case, with the application again, maybe?
Yeah, absolutely. So in terms
of that one thing.
No, sorry, I'm interrupting you.
No, I said that's one thing. Yeah.
So there will be wasted costs, there'll be wasted court resources, and it is a material factor, I say, that whatever delay there is to this application will also delay the claim, which is very long delayed already. Limitation periods are there for a reason. I accept, yes, if you sign up to a standstill, you sign up to some risk that period will be longer than you anticipated. But nevertheless, that is an important factor in considering what are the consequences of adjourning off today. Because we're already, as I say, we will be 10 years past the earliest date that my learned friend says documents are relevant. And the factors of
another things come to my mind. What if we dismiss this stay application, we abridge the jurisdiction barrier, we grant the pre-action disclosure, they're going to be a lot of burden, and then 2, 3, 4, 5 months. And no, it was not put that way, but I'm allowed to think that way, I guess. And then proceeding vanished. We don't know what happened. It is waste. It's a big
Well,
waste.
it'll compress whether
Courtholders,
you
myself, claimant, and yeah.
I of course, I'm resisting the
It's
stay.
it's one possibilities, isn't it? I mean,
of course it is. Of course it is. I'm resisting the stay, and of course it's possible that Your Excellency, if you agree with me on that, will go on and consider the application and grant it. And we say there are powerful reasons why you can't. Some of them legal reasons, and some of them discretionary reasons. But we say you don't actually have the power to grant pre-action disclosure after proceedings have commenced. There's a long line of authority in England about that. And my learned friend's case is, oh, well, it's just a bit different here, and we'll explain why. But none of those reasons we say make any sense. So, but whether you agree with me on the main application or you agree with my learned friend on the main application, our position is we have spent money on this. We've spent court time on this. We've spent everybody's time and resources on this. If it's going to happen, let's get on with it. And it shouldn't be delayed simply because the claimants don't have much appetite to pursue their own application. We say that it's time just to put up or shut up in relation to the application. Everyone's ready to do this and argue it.
But we all know the claimant can make an enhancement to this application. It's been pleaded, skeleton argument submitted in regard of both, and then they can't add anything. It's the only thing is need to be decided again, and maybe the court and the parties would remind themselves what is the application and the defense. Your defense is written in this anyway, Mr. Smith. You know, we have it written. I don't think even we wouldn't accept, I mean, any change of circumstances in regard of this application. So it will be heard as it is in the future. The only thing that you and I would take extra hours in reminding ourselves of it, and then we go on. It could be me, could be another one. I'm not sure, but it could be you, could be another one too as well. Yeah, but I said the bleeding is there, the submission is there, it's lodged and everything. I mean,
yeah, but then we'll be doing this another year down the line. In reality, well, my learned friend says it might be a few months, it might not, but at the moment it's not just a question of the stay in the local courts. He says then we have to have they have to have the whole fight about the ownership in the local courts after that. So the chances of us getting back in front of you, Your Excellency, or another judge in the DIFC court within 3 months are very low. The reality is we're looking at what, the best part of a year? Who knows? Could well be that long is the best we can put it.
We might not come back at all. One possibilities.
Well, what? Yeah, well, so I think what you're suggesting is perhaps my learned friend's clients might think better of it all, or alternatively they might lose the ownership battle. Well, that's true, but at the same time, one thing that you can be sure of is that if you go ahead and hear the application now and dismiss the stay application, no further costs will be spent on this argument. We will simply deal with it. No further court time will be spent on this argument. We will simply deal with it. So it's undeniable that there will be wasted costs as a result of any stay. It's undeniable that there will be waste of court resources as a result of the stay. And it's clear that it will also have the effect of extending the limitation period. And it means that if there are allegations being made about things that were said in meetings, and that's possibly one of the arguments that's going to be raised, we're going to be another year down the line from those meetings.
Are you saying I should go forward and either dismiss the pre-action disclosure order and that's it, or grant it and then state when it's come to enforce it? That's the end of the story. Is that your suggestion, Mr. Morrison?
No, my suggestion is you just go on and decide the pre-action disclosure application, and if that goes against me, that goes against me, and if I succeed, I succeed. But what I cannot see as justified, and Your Excellency would have to accept that there were unusual circumstances that gave rise, exceptional circumstances gave rise to the need for it.
What I do have some difficulties, as Mr. Counsel said, we're not talking about a major hearing trial date or even hearing trial date to be, and this is still, I mean, pre-action disclosure. It's a party that who wants to put his case together. I mean, we're in. I mean, well, at this dormant stage, I guess. But I said I'm not deciding the application. I'm just thinking loud. I mean,
Yeah. Well,
and
so
see
in
where
relation to that,
where the balance lies. I mean,
yeah, I mean, in relation to that, I'm just looking for the reference that you're aware of the rule. I think it's 2690,
right.
which says litigants and legal representatives must be in no doubt that the court will regard the postponement of a trial as an order of last resort. Now, that's the one that one of the ones that I rely on. And there was a case which was Part 8 proceedings, in which the question was whether there should be an adjournment of the Part 8 hearing. We refer to it in our bundle, in our skeleton argument. I think it was the Al Rehab case, the NVD case, where they applied those rules to a Part 8 case. So I don't think, and that's Court of Appeal authority, so I don't think it can really be contested that that rule applies to the question that you have to decide today.
Can you take me to that, please?
Yeah, sure. Bear with me 1 second and I'm going to... So the rule itself is at tab 49. It's I 49 2690.
For 26.
26.90. That's the rule, and then the authority is EMBD Bank. It's referred to at paragraph.
Yes, we need to look at last resort, and then we go to the what's the other three?
So your question, I think, was: is this a trial? Does that rule apply? That's how I understood it.
Is this adjournment? Is the last? Yeah.
And the answer to that question is that particular rule was applied in the case of EMBD Bank and Al Rehab, and I confess I hadn't anticipated taking to it, so I hadn't checked that it was in the bundle, and it might not be for whatever reason.
That Rehab and Kasab, isn't it? It's a case I've dealt with, I guess.
It was in the
Court of Appeal decision, I say.
Correct. And the effect of that was what was happening there was that there was a Part 8 claim, in that case for foreclosure, if you recall.
Mm-hmm.
And an application was made at the last minute to adjourn the hearing. And so the issue, one of the issues in the case, was what are the principles pursuant to which the court will decide whether to adjourn or not. Oh, I thank you. It's tab 15, I'm told. Oh, that's perfect. What are the principles? And so this was a Part 8 case. And if you go down to paragraph 121, you will see at page 211 that issue was decided by reference to the rule I've just shown you. So the fact that this is a Part 8 claim does not mean that this doesn't count as a trial for the purposes of 2690.
What paragraph?
121. It's on page 211.
221. I see the last one. Yeah. Okay.
And you also see it at paragraph 127 on the next page. Where they explain that the policy behind that rule is that the adjournment of hearings is a last resort. And I apologise. I had, of course, forgotten that Your Excellency was sat on that appeal panel. So it is an order of last resort. My learned friend accepts that he needs to establish rare and compelling circumstances. And that doesn't just mean that there's an unusual case or there's an issue of fraud somewhere in the background. He has to show that it's having an impact and it justifies a stay. And for the reasons I've explained, I say that he just doesn't get close to that. He's authorised to act. That's his own evidence. He's been instructed in the past, at least, to pursue this application, there's no evidence to explain what are these difficulties in obtaining instructions that he refers to. So for those reasons, we say that he can't justify this application, and you don't get to the question of prejudice because he just doesn't make it out. But there is real prejudice here for the reasons that I've explained, but I won't repeat myself. So, Your Excellency, unless there's anything further you want from me on the stay, if I can help you any further on that, then those are my submissions.
Thank you. I will turn on to the claimant who's
can I
the last to speak? Yeah, maybe.
Can I come back just very briefly? Just I don't know whether you still have it open, that
yes, I do. Have, yeah.
127. Well, what's interesting, if you turn to paragraph 127, is that the court goes on to say in the second sentence, the judge doesn't say so expressly, we'd expect that he also took into account the policy evident in 29.6 to the effect that adjournment of hearings is a last resort. If this court were to adopt a practice of condoning complete inaction following service of legal proceedings without any cogent reason or justification, and then rewards such inaction with the grant of an adjournment of a listed hearing following an application brought at the last minute, the orderly business of the court would become shambolic to the detriment of all litigants. And that's fairly self-evident, but that certainly isn't this case, with the greatest of respect. This isn't a case of, remotely a case of complete inaction, and it certainly isn't a case where there is no cogent reason or justification. And can I just make a sort of observation, really, listening to my learned friend's submissions. His complaints about what he says are the inadequacies of Ms. Sheffield's statements, the failure to be more precise, the failure, he says, to provide a witness statement from somebody who does have management and control of the first and the third applicants, precisely illustrates
it's a witness of fact, yeah.
The point that we have. He says, for example, well, there's no difficulty here because, of course, there are directors and they will continue to act. That's not, of course, the case because, as Your Honour will know, this isn't a case of boards of directors. A company such as the first applicant and the third applicant is run by a general manager. And what the documents that have been provided demonstrate is that the general manager, the person who would have to make that statement, has been changed. Can I take you back to the documents that you've been taken to already? If you go back to section 3, to that document we looked at page 82, do you remember? That's the new license. I call it the new license. And it's the one dated the 19th of May, and the one that Ms. Sheffield produced in her original witness statement dealing with this. You can see that the general manager is set out on there. I'm instructed that the name in the middle of that page, Mohammed.
Sorry, give me the reference again.
Yes, it's page
A.
Did I say 82? My mistake. Page 74 of that tab. This was the license as it is now, effectively. So this is the fraudulently changed license, and it's the one that I took you to show the date, the 19th of May. And my understanding is that the name of the general manager has been changed, and it appears there as Mohammed Abdullah Juma, which is Mohammed Al-Sari, as I understand the name that he would use there. And so he has legally become the general manager of, in this case, A3, applicant number 3. And for all my learned friend's indignation about what he says are the inadequacies of Miss Sheffield's statement and the failure to provide a statement from the general manager, this precisely illustrates it. We can't do that because the general manager, the person in control of this company at the moment, is somebody from whom, of course, we can't take instructions and have no control over. If you go back to the page 72, which is the previous version of the license, you can see that the name under the general manager's name is there, Majid Al-Sari. That was the original one, the one from whom we could take instructions. And to the extent that Ms. Sheffield has been able to do so, as she sets out in her witness statements, she's received some instructions from Mr. Majid Al-Sari. But it precisely illustrates the criticisms now made by my learned friend, the impossibility of the situation which the claimants find themselves in. And you know, I make the point again, but let's just assume the worst came to the worst and we were unable to recover ownership. Then where does that leave all of this? Mr. Mohammed Al-Sari will be saying, well, this was an application which was preceded by solicitors. I happened to instruct it as general manager, and without any instructions from me, and without my providing evidence about it. And we're in an impossible situation. And so this isn't a case of a board of directors who continues. This is a general manager who controls this, purports to control this company, who's simply not involved in these proceedings. With the greatest of respect, this just simply is, to use my friend's words, he says, well, the applicants don't have any appetite at the moment to pursue this application. That's not this. We would want to get on with this application were we able to do so. And also, with the greatest respect, this is not an indefinite stay. We are taking steps to seek to recover the position. There's no way in which we're asking for this to disappear off into the ether and never come back. This is an application which has been made for very good reason in wholly exceptional circumstances, and one which, with the greatest of respect, I'm afraid, needs to be granted. If it's necessary, if it would provide comfort to the respondents and to the court, then of course the solicitors, my instructing solicitors, will provide regular updates to the court as to the progress of having the stay lifted from their proceeding with the court proceedings to recover, and where we are with that, so that the matter can be closely watched and no further time is wasted. Jonas made the point quite rightly in my submission that the reality is that whilst there may be a wastage of some costs, the vast majority of the costs have been expended and will need to go ahead anyway, and there won't be a great deal of costs. Some time taken, of course, in bringing this matter back so that it can be argued either before Your Honour or before another judge in due course. It's a matter of great regret that we need to make this application, but it does need to be made. And if we don't make it, then there's a real danger that this case will end up with further applications being made in due course. And those are my submissions.
Can I just say one thing, Your Excellency, which is my learned friend mischaracterises my submissions entirely about Ms. Sheffield's evidence. I don't criticise her evidence because it doesn't come from the general manager of the company. I criticise her evidence because it doesn't come from the person with knowledge of the facts. That's what's required. And then, of course,
you hear me commenting on that during his, yeah.
Thank you.
Well, let's see. I think is the best things to do is to break for now for about an hour. And then when I come back, you will have my decision about the stay. So if there is a stay, so that's the end of all hearings of today. And if there is no stay, then we would hear the rest of the application.
Thank you.
And
Very good.
if I may suggest that we are coming back, let's say 2 o'clock sharp debate time.
Yeah.
It's like 1 hour and 10 minutes.
Thank you very much. Bye.
Thank you.
Thank you. See you then. Good afternoon.
Good afternoon, Your Honour.
Good afternoon.
Well, I have looked at the stay application. I have looked at the ground, at the basis of it and the defense. And my conclusion is the application is dismissed, Mr. Counsel. I think the court are willing to go ahead to hear the pre-action disclosure in its both limbs, jurisdiction and the merits.
So be it. Well, let me make a start on that and crack on, because I'm conscious we're quite short of time now. And if I don't take you to every passage in my skeleton argument, forgive me, but we've got quite a lot through. Your Honour, I set out in paragraphs 5, in fact, down to paragraphs 14 in the skeleton, the background to this claim and the basis that, as the applicants see it now, of the claim itself. And I'm not going to repeat those. I know that I took you through those on the previous occasion.
Yes.
I just invite you to read all of that. And just picking it up at paragraph 14, I refer there to some agreements which we say all form part of the agreement between the parties: subscription agreements, credit facility agreements, undertaking agreements, undertakings and guarantees. And I think the skeleton contains the page references for that.
This is, I think you mentioned, I think it's paragraph 13.
14.
Yeah, sorry, a number of subscription agreement, credit facilities agreement, together with various addendums, undertaking agreement, investment agreement, guarantees.
Yes, it is paragraph 13. Forgive me. It is paragraph 13 rather than 14. I apologize.
I'm good with
then I set out the procedural history in paragraph 16, which is checking the paragraph 15, in fact, of my skeleton, and then skipping on, if I may, because we then deal with the stay arguments which you've heard.
Right.
Picking it up at paragraph
28, maybe
30, the outcome of the first jurisdiction hearing, and you'll recall that the parties were arguing that there was a different threshold test to be applied, and I've set those out at 30A and B, won't repeat them. And then briefly a quotation from your decision at paragraph 31, and you say in the middle of that, transposing these principles into the present context, I would say that where the court finds, taking a broad view of the application, some reason with at least a minimal level of arguability to believe that the DIFC court has jurisdiction, the court should go on to entertain the application for pre-action disclosure. Perhaps this can be abbreviated to a beyond arguable test, which is the one I propose to adopt in these submissions. And we just make the point at 32 that that's consistent with the English authorities and refer to the case of Landis. So then coming on, first of all, to summarise my submissions on jurisdiction, applying what is quite a high threshold, we say three things. First, that because the first respondent has accepted jurisdiction, we say that the DIFC court should have jurisdiction over the remaining respondents as necessary and proper parties. Secondly, that in any event, most of the gateways in Article 5A of the JAL number 12 of 2004 apply. And thirdly, in the event that it's pursued by the respondents, there's no proper basis for the court to decline jurisdiction on the basis of forum non-convenience. So turning to each of those in turn and going quite swiftly through this, first of all, necessary and proper parties. I refer to Rule 20.7 of the RDC, may order a person to be added as a new party if it's desirable and if there's an issue involving the new party and an existing party which is connected to the matters in dispute. And of course, as is set out in the Nest investment case, the RDCs constitute DIFC regulations for the purposes of Article 5.1e of the JAL, although in fact the test in Rule 20.7 is not one of necessity but of desirability, as we've seen from the passage which I cite. So where does that take us? Well, first of all, the court has jurisdiction over the first respondent because it has abandoned its challenge to that jurisdiction. And that's relevant, not just because now the same arguments are being run again, but also because the first respondent's acceptance of jurisdiction, we say, makes the remaining respondents necessary and proper parties under Article 5.1ae, so that it follows that even without the jurisdictional gateways on which we rely, the court doesn't in fact need to go so further, remembering that it's a high threshold for the respondent to argue this, because the fact that there'll be a substantive claim against R1, I apologise for abbreviating to R1 if I may.
No, that's fine.
It clearly makes it desirable that they should be added to proceedings as necessary and proper parties. That jurisdiction is conferred by Rule 20.7 of the RDC and by Article 5A1E of the JAL, as established in the case of Nest, with which you'll be familiar. Why do I say that? Well, we say that because given that it's no longer disputed that there's jurisdiction over R1, when substantive proceedings are brought before the DIFC courts, the court is likely to rule that it would be desirable that Rs 2 to 4 should be added as necessary and proper parties for the following reasons. And I set those out in paragraph 44, just checking I'm looking from the same numbering as you. Yes, we are. First, there is a substantial body of evidence before the court demonstrating, we say that the first two respondents portrayed themselves as a unitary entity to the outside world. Can I come back to that and deal with that in a little bit detail later? But there's evidence of that from the website, representation made by employees and the terms and conditions of business. Secondly, I'll come back to that, it would be not only artificial but highly unsatisfactory if there were separate trials in separate jurisdictions, if the case against one of the respondents had to be conducted elsewhere, because it's obvious that they're both operating entities for the bank, conducting business in the UAE, and where the underlying facts giving rise to the dispute are the same, and where the interactions between each respondent will be highly material to the duties that they owed, that there should be a trial in the same place. And next, this is not a case, we say, where there's been a clear and unambiguous election that disputes would be resolved elsewhere, even if that were a determinative factor. We've got competing provisions, which I'll come back to. On the one hand, the subscription and credit agreements say one thing, on the other, the undertakings and guarantees say another. And if I may, I'll come back to that to take you to where we can see that. And although
excuse me, the agreement and the guarantee are between, and namely in personnel, R2, respondent 2, and the claimants. Is that right?
Yes,
not R1.
Yeah, that's correct.
So are you putting a heavy weight, or I would say your only window to engage R2 to 4 with this in this jurisdiction is to show us evidence R1 is to be in this case.
Yes, we would say
Without bringing R1 into this case, then you didn't have jurisdiction. Is that the way? And then you would try to show us some evidence R1, R2 as like acted as a one unit or one or one form, or R1 got some engagement with this or led you?
Yeah, the essence of this, and we say it's certainly not beyond argument that this isn't the case for this.
Well, yeah, I'm saying, yeah. So the lower threshold is.
Yeah, is that there is plainly evidence, which I'll, if I may, come to when I get to the gateways.
No, I just need to understand. So that is the main gateway you're looking at.
It is, yeah.
Sure,
It's the unitary entity point, which is fundamental to all of this. And I'll come on to that if I may.
I see that.
And then just coming back then briefly, the respondents cast doubt on the validity of the undertakings and the guarantees, but we say, and we'll come back to their arguments, we say that this is not the place, an application for pre-action disclosure for the court to be able to reach any conclusions about whether it's the undertakings and guarantees which are valid, or whether it's the subscriptions and credit agreements, or both, or what the position is. I know, Your Honour, that you're very familiar with the cases of Protabiti and Smith because you referred to those in your ruling, and I don't take you to those. In looking at this and standing back, the court will, in my submission, want to have the bigger picture in mind. It's considering a set of potential claims in which the parties are all based either in the DIFC or at least in the UAE. The underlying investments in the fund are assets situated in the DIFC or the UAE. The relevant witnesses are based in the UAE, and the documents sought by way of pre-action disclosure are also to be found in the DIFC or the UAE, or as we're now told.
Yeah, but why are we saying this? We just agreed your only gateway, Mr. Counsel, is that R1 or the defendant one has taken steps or engagement with your client in the same cause of action.
Yes, well, I don't rely on just that matter. That is the principal point that I make. And can I move on to the
well, I tell you, I say so. Are you saying there is a secondary point that even if R1 said not to get engaged with this at all, okay, if the case is dismissed against R1, then you still say there is another link would bring R2 to 4 to the DFC jurisdiction? Well, it's not this. I don't think it's your case is bleeded this way, isn't it?
No, my case is that we rely on a number of the gateways, and one of the fundamental points we rely upon is the unitary entity, which I'll come to deal with if I may. I just wanted to take you through, if I may, in a logical way, and perhaps start with picking it up at paragraph 47 in my skeleton, with Article 5A1 of the JAL.
I see that, yeah.
Where we set out the various gateways, and then 5A2, and then to remind Your Honour that, of course, the court's practice is to adopt a broad approach in relation to the interpretation of Article 5A1, that's the Karafi case, and making the point that you had that well in mind in your decision in this case earlier, where you, I think, were referring to the case of Camel. And so then coming on, I'm sorry to take rather a long time to get there, to Gateway 5A, 1B and C, first of all, if I can deal with those two together. So I'm up to paragraph 52, contracts which were wholly or partly performed in the DIFC, or incidents or transactions which were wholly or partly performed in the DIFC. And again, making the point that these provisions are intended to be broad in scope, and we've cited there some paragraphs from the decision of Al-Karafi, which I don't read out. Perhaps, if I may just pick it up at paragraph 63 in that decision, where we're dealing with incident, meaning to be accorded to incident, comprehends any of the essential elements of conduct or the incidents of loss or damage necessary to give rise to a cause of action, meaning to be accorded to transaction is any commercial relationship between the claimant and defendant giving rise to mutual rights and obligations. The second and fourth respondents' contention is that the court doesn't have jurisdiction because R2 was not a party to the contracts. R1 was not involved in the transaction. The material contracts were not concluded or performed within the IFC. And these raise factual issues, which in my submission can't be dealt with today. But just looking at the single unitary entity point, and I apologize for taking so long to get there, can I take you to some of the documentation? So if we can go to the bundle, first of all, the bank's website. So would you go to tab 3, which is Miss Sheffield's exhibit, and
yes.
To the
Page number?
Page 77 in the bundle. My apologies.
It looks like 77 is a blank page.
I have a wrong reference. I do apologize.
James, are you looking for B77? Is that what you're
yes.
after? Bundle
yes.
B, page 77.
Yes. I'm sure that's a correct page reference.
Yeah, I have it.
Yeah, it's behind tab 3 in bundle B.
Yes, I'm having a problem. I do apologize. Would you give me a moment just to
Please.
sort it? I'm looking for the page from the website and I'm struggling to find it because for some reason my bundle is something's gone awry with it. I don't understand.
I'm sorry to interrupt, James.
Yeah.
It may be that you're in the wrong bundle. So above the tabs, so above the A tab, you'll see change. Do you see that on the left-hand side of the screen? You ought to be in O3 stay application and PAD. If you're not, click on change and you can find a different bundle.
No, it's very helpful, but that isn't the problem. I'm not quite sure what is. Does you want to have page 77, which is a page from the the website? I'm afraid I don't, but I can remember what it looks
I
like.
do. It says Julius Baer, then Dubai, then United Arab Emirates.
Simply the point that the bank's website lists the first respondent, Julius Baer Middle East Limited, as its relevant contact entity for Dubai-based clients. That's the only point I want to make about that. And then moving on to the second point, which is that there are email communications oh dear, I do apologise.
No, so what's inference you would like to draw from this website thing? Is that because Julius Baer Middle East next to it address DIFC?
Yes, it's the first respondent who's being advertised there as the relevant contact entity for Dubai-based clients there. And similarly...
And how this help your case, Mr. Counsel?
Well, it demonstrates, I submit, it's one part of demonstrating that the applicants were presenting themselves as a single unitary entity to the outside world. They were, on the one hand, advertising JBME, Julius Baer Middle East Limited, as the relevant contact entity, and on the other hand, employees were putting themselves forward, as we can see, if I can find it, and I'm really struggling at the moment. I do apologise. I need to find the right document.
The bundle reference is B88, I think.
Yeah, I know, but for some reason, mine isn't.
I think you cannot navigate through the system completely. Is that right? You have navigation problem?
I do. I'm using, I may need to try something else. It's my fault. I do apologise, but I need to try a different way of dealing with this.
Take your time, try to fix it.
Yes, thank you very much.
We will be patient with you.
I have no idea why it's doing that.
What James Bond said, accident happens.
Yeah, it's very odd. I'm actually using a copy of the bundle which isn't on the system, and I should now revert to the system because that has not worked. Thank you. So I'm now on B88, and I apologise for taking up.
That's great. Good news.
And what we have here is one of a number of email communications sent to the applicants from in this case Rajesh Sharma. I apologise, from Nada al-Yazdi, from Anila Nair of Julius Baer, and we can see if you scroll down that Anila Nair is the first respondent, and she's communicating with the applicants in that one. And if you turn on to page 91, you can see another example of an email from someone else, first respondents, dealing with correspondence with the applicants. And there are similar examples at page 93 and 94. And then if I can take you to
what reference made to the DIFC firm here? I can't see it. What reference made to the R1 here? I can't see it. This is directly from.
This is from R one, R2, R1. The R1's name appears on these emails.
Page 88.
Yes.
In these three different squares, like.
The name is on page 89 in the middle.
If you scroll down, and thank you very much. If you scroll down to page 89,
yes,
you can see at the end of the email the name Anila Nair, Associate Director, and you can see under that she describes herself as being an Associate Director at R1.
So this is starting, says our routing instructions for transfer are. And then they're listing USD,
Yes.
EUR, GBP, and then IPAN, but then shift the Swiss franc, I guess, or something.
Yes.
And then Julius Baer and Co. Geneva, Zurich, and then Julius Baer Bank, Geneva, Soor Investment. So, okay, so the email address, isn't it? Is that what's showing is DFC?
Yeah.
Julius Baer, Middle East, Dubai International Financial Center. So the person contacting your client is acting and using email address of a DIFC entity, which is R1. Is that right?
Yes, that's correct.
Oh, I see now.
And the next point, if I may, is a point made by Ms. Sheffield in her first witness statement. So can I invite you to go to tab 2?
Tab 2, B2, you mean?
Yes,
B2,
tab 2, which is Sheffield 1, if I can call it that, and to paragraph 15. I'm very relieved to say that I've resolved the technical issue I had, which was causing me problems. And you'll see at paragraph 15, Ms. Sheffield says, at that time, the bank's designated relationship manager and contact point with the applicants was Ms. Nada Al-Yazdi, who was based in the DIFC, and whom I'm informed by the applicants that they reasonably assumed to have been employed by the first respondent. Initially, the applicants placed regular trades as clients of the first respondent in international securities with the bank through Ms. Yazdi as their relationship manager. And then next point we rely on is correspondence purportedly sent to the applicants by an executive board member of the bank, which was distributed to the applicants by employees and agents of the first respondent. And if you'd go, please, to tab 5 of section D for this, please, which is Ms. Sheffield's witness statement, and at paragraph 16 on page 102 of D102.
yes.
She makes the point, that point is further underlined by the extent to which, in setting out its jurisdictional challenge, the first respondent has almost entirely directed its efforts at addressing the question of whether the court has jurisdiction. Once again, the first and second respondents are conducting themselves in a manner which indicates they were effectively operated as a single unit, and you can see at paragraph 15 an example of that. I'm informed by the applicants it also received correspondence from Mr. Remy Bercier, an executive board member for the bank, on the 16th of February, which, although sent on the letterhead of the second respondent, was sent to the applicants by the first respondent in a communication that was expressly stated to have been distributed by Julius Baer Middle East Limited. And if you turn to the exhibit, you'll see that. If you wouldn't mind looking at the next tab, tab 6 is the exhibit SGS2, and you'll see an email at 110 to Mr. Abdallah Al-Sari. I hope this mail finds you well. I thank you to find attached on behalf of Remy Bercier a letter to your kind attention, and that's signed off by Miriam Burry of the first respondent, and the letter appears on the following page, and you'll see that that's a letter from Bank Julius Baer. It's from a member of the executive board, and we can see it's addressed to Mr. Majid Al-Sari, and dated the 16th of February, and you'll see it's a letter that he sends as someone from R2, but sent to the applicants by someone from R1, and that precisely demonstrates we submit these two respondents, first and second, operating together as a single unitary entity. And as we now know, the respondent and the first respondent and the second respondent have shared systems of managing and archiving documentation, including, as we know from Mr. Lyons's statement, paragraphs 45 to 49. Just to give you the page reference, it's at B tab 13, pages 470 to 471. They have shared systems, a centralized server said to be in Switzerland, used for managing client data obtained by both respondents' representative office in Abu Dhabi, a shared human resource department based in the first respondent's DIFC office, but performing services in relation to employees situated in the second respondent's representative office. And that's all set out in Mr. Lyons' statement. And in any event, we submit that R1's central involvement, apparent as an agent or intermediary for R2, can clearly be seen from the first respondent's additional terms, which provide that it was intended to act for and on behalf of the second respondent and other entities of the bank. Can I take you, please, back to section B of the bundle?
Yes.
To tab 3 again. That's the exhibit from Ms. Sheffield, and at page 151, you'll find the additional terms and conditions. And then at paragraph 2 over the page, entitled in the right-hand column, Information and Communication Authorization, the client hereby appoints and designates R1 to be the client's contact with the bank or any other member of the Julius Baer Group, and confirms that for the purposes of this clause, the authorization acknowledgements are intended to be for the benefit of both R1 and R2. The client acknowledges and hereby authorizes JBME and its employees to collect, use, transfer and exchange in any or all documents, data and information stored in JBME's and the bank's own electronic system. JBME may work with any member of the Julius Baer Group and third-party service providers who may process client data. And then at 2.3, the client hereby agrees to communicate with the bank primarily through R1. The client agrees to forward messages and orders addressed to the bank via JBME. JBME, in its capacity as an intermediary between the bank and the client, will forward those orders and messages to the bank. The client agrees that the bank may also send its messages addressed to the client through JBME. So what we say is that there is a good arguable case here, but of course we don't need to reach that threshold for today's purposes, to show that R1 and R2 were acting in concert. They were acting together as a separate legal entity. And it's accepted that at least part of the underlying assets in the fund in which they invested are shares in DIFC-based entities. And on that basis alone, we would submit the subject matter of the dispute relates to transactions which were at least partly performed in the DIFC, all that we would need to do in our submission at this stage. And that's accepted by Mr. Mackenzie in his first witness statement, which he made for the previous hearing. Again, just to give you the page reference, if I may.
Sorry, it's you know that there's a dispute about that because it came up at the last hearing. So my learned friend's presenting something as being uncontroversial when it is controversial. It's not accepted, and that's not what Mr. Mackenzie says. And you know that that's what I said at the last hearing.
Well, forgive me if I misled the court. Let me look at what Mr. Mackenzie says. It's at.
I'm sorry, I'm not aware of this issue. Would you please, one of you should make it clear for me?
Well, Your Honour, can I just take you to what he says? And if my learned friend wants to make different submissions in due course, I'm afraid I certainly don't mean to mislead.
Sustain, go on.
Perhaps I could ask you, please, to turn to tab 3 in section C. So C3 is the first witness statement of Andrew Mackenzie. And if you'd go to page 35 in C3, you'll see at the bottom of that page and over the page, paragraph 108, he sets out what he says the applicants are arguing. And then he says, on this basis, the applicants argue that the investments in the fund are transactions that have been at least partly performed in the DIFC.
What paragraph you're reading?
It's paragraph 108 at the bottom of
last one. Yes,
C.
I see.
Yes. Yeah. Second sentence. On this basis, the applicants argue that the investments in the fund are transactions that have been at least partly performed in the DIFC under 5A1C. Importantly, the fund itself is not registered or domiciled in the DIFC. Moreover, whilst the fund may hold shares in DIFC-based companies, the subscription of units in the fund does not confer any ownership rights in the shares of any of the companies pooled in the fund. The subscription agreements confirm that R2 is the legal owner of the units in the fund and it held them beneficially for the applicants. The applicants' reliance on this gateway is, he says, fundamentally flawed. So I hope that sets out what he says. If you look at the schedules to the subscription agreements, and that means going back again, if you would, Your Honour, to B3, to Ms. Sheffield's first exhibit, and to the subscription agreements, which appear at beginning at 253 in B3. We've got there a subscription agreement. And if you turn to the schedule, the appendix to those agreements, there's an example at 264. You can see there one of the security names is DEPA, which is short initials for the Dubai for DEPA PLC, Dubai International Finance Centre, which is an investment company based in the DIFC. And so one of the investments used for this fund is DEPA. And if you look through again, there's another example of that at another subscription agreement appendix at page 270. DEPA appears again, and you can see a schedule, perhaps dealing with this in this way. If you go on to page 301, you can see a schedule of investments in the fund into which the applicants invested. At page 301, which I hope is
the proposed credit facility, is that one?
Yes, and you can see DEPA's name appearing 3 times in the third column there, 30th of November, 11th of January 16, and third time 30th of November 16 against certain amounts, specific amounts of money. And on that basis, then we would submit the subject matter of the dispute relates to transactions which were at least partly performed in the DIFC, and applying, as one does, a broader approach to this, one in my submission can see that the gateway is made out. So given all of that evidence, we would submit that R1 was acting as agent or intermediary for R2. It follows that the contracts concluded between the applicants and R2 were at the very least partly performed, and indeed may have been wholly or wholly concluded or partly concluded in the DIFC by R1, acting in that capacity. And it certainly can't be said that this is beyond argument, that given the extent of R1's involvement, the dispute did not relate to incidents or transactions which were wholly or partly performed in the DIFC.
Well, but we know any entity in DFC could have dealt with R2 even beyond R1. Because
I'm sorry, Your Honor.
I said any entity within the DFC or any fund or investment within the DFC could have dealt with R2 instead of R1 directly.
Yes.
Without R2 and
well, we would,
yes,
we would
at
say
least, yeah.
The whole picture here is of the two of them acting together in relation to these investments.
Yes.
In my submission, even if the test were higher, that we had to show a good arguable case that this gateway will be established, but of course we don't. The test is much lower than that. For the respondents to succeed in relation to this argument at this stage, they would need to satisfy the court that it is beyond argument that there's no jurisdiction under this gateway. And with the greatest respect, in my submission, they come nowhere near establishing that. And so, moving on, if I may, we also say that our Article 5A 1E is established, namely breaches of DIFC laws and regulations. We deal with this at paragraphs 60 and onwards to 64 in our skeleton argument, making the point that this simply isn't a case of a straightforward breach of contract dispute. We say that there are claims under the DIFC laws of obligations and claims potentially for breaches of the DIFC regulatory law and breaches of DFSA rules. We set out why we say that. They are allegations of negligence and breaches of regulatory provisions regarding investment advice and products, including a failure, we would say, this is the applicant's case, to carry out an adequate assessment by the respondents of the claimants or the applicant's needs and experiences as an investor, failures to provide suitable or sufficient appropriate information about those investments, failure to provide adequate advice on the suitability of investments, and as I say, potential breaches of facility agreements in the manner that the margin calls were handled. And I've skated over rather the background to this case because I know that we took Your Honour to those last time. And those are disputes we would submit that the DIFC court plainly has jurisdiction over. And it's to turn the correct test on its head, it's unarguable that that is not the case. And so in our submission, certainly at this stage, Article 5A1E is also engaged. And then...
excuse me, Mr. Counsel, I mean,
yeah.
the accusation of under 5A1E for, I mean, breach of law of obligation is directed to R1 only, isn't it?
Well, we would submit that it will be necessary, and this is a disclosure exercise we're dealing with, to obtain.
Because is the regulated party within the DRC, yes. So isn't it? He would be bound by the regulatory law. Yes,
we wish to seek disclosure from both respondents so that we can make out that case.
I see.
And then moving on, if I may, to 5A2, the opt-in jurisdiction, agreement in writing to file such claims, and we have these. First of all, the undertakings and guarantees, and can I take you to one now, now that I'm back on track and able to look at the right?
Yes.
The undertakings, if you turn please to page 78 in B3, the undertaking agreement, which is set out there, described in subparagraph D of the paragraph D of the recital as being an additional terms to be included in the subscription agreements. And then the undertakings are set out on the next page, and over the page to page 80, you can see an opt-in clause there. This agreement and the covenants and obligations under it shall be interpreted and governed by the laws of the United Arab Emirates as applied in the Emirates of Dubai and the Dubai courts, and wherever applicable, DIFC court should have jurisdiction to settle any dispute arising out of or in connection with the execution or interpretation of this agreement or any of its terms and conditions. And there are other examples of that opt-in clause in the other undertakings and also in the guarantees. I won't take you to unless you'd like me to, but if we look at page 80, we'd find page 84, we'd find similar wording in relation to the guarantees. And on its face, in our submission, that amounts to an opt-in clause, which is sufficient, certainly at this stage, to engage Article 5A2 of the gateways. A number of points are made by the respondents, but they're not points really that with respect can be made now. It's suggested, for example, that the documents aren't signed by R2. Well, they're not meant to be signed by R2 with respect. They only contain sufficient, as you can see from B80, for one signature. And interestingly, if you turn to the subscription agreements on which the respondents do rely, an example of one is at page 253 in B3. You'll see that on page 254 that those documents don't have space for two signatures either. So that's certainly not a requirement of any of these contractual documents. And the provisions of these agreements are clearly relevant to the underlying dispute, given what's known about it at this stage. Next, it's suggested that the lack of reference to DIFC courts in some way prevents jurisdiction being conferred on the DIFC courts. Well, we've referred to two cases which will be familiar to Your Honour, I know, IGPL and Suntec, where the courts have made clear that one should interpret references to the Dubai courts and courts of the UAE broadly, so that they should include both the DIFC and non-DIFC courts of Dubai, if necessary. As I've repeatedly said, there's no arguability threshold here in determining the question of the court's jurisdiction to grant an application for pre-action disclosure. And in my submission, this gateway is plainly engaged. And fifthly, the last suggestion made in answer to these undertakings made by Mr. Mackenzie was that they were forgeries. That is a marked departure from the position which he previously adopted, where he described them as minor addendums to the skeleton agreements. That's paragraph 37 of his, I think, first witness statement at D2, page 13. Of course, there's going to be a factual issue in relation to if there is to be a factual issue, but that's not something which you're able to resolve at this stage. And it's therefore, in my submission, clear beyond argument that the DIFC court, or clearly not beyond argument that the DIFC court would have jurisdiction under 5A2. And I just briefly deal with it, but just take you to the paragraphs in my skeleton, given the time. Article 5A1A, the DIFC centre establishments, we also submit that it could be extended to this, just as in the past the DIFC court's jurisdiction has, which is interpreted as being very wide, extends to entities with branches in the DIFC, even if the subject matter of the claim is not related to that DIFC branch. And then dealing briefly with forum non-convenience, if it's a point which continues to be taken, namely that you should decline jurisdiction even at this stage on the grounds of forum non-convenience. Now is simply not the time for arguments with respect on forum non-convenience. It's accepted, of course, that the court may decline to exercise jurisdiction. Whether it's appropriate to do that now is another matter. We take you at 74 to the two-stage test in Spiliada, established in the English courts and adopted in Protabiti. First, the defendant bears the burden of establishing there is another forum which is clearly or distinctly more appropriate. And secondly, even if it is, the court will need to consider whether there are reasons for concluding that the interests of justice nonetheless require a trial in the DIFC courts. I take you to some authorities in relation to that, and on the test to be applied. And then moving to submissions at paragraph 80, we would say that the submission that this is not the appropriate forum just simply doesn't work, even if you were able to reach a determination about that now. The DIFC court, 81A, can and frequently does exercise jurisdiction over cases notwithstanding the existence of a jurisdictional clause, even if one were to have doubts, and one can't, about some of the documents in the bundle. Protabiti and Tavira are two examples of that. The Karafi litigation provides a good example in the context of a mis-selling claim, and the DIFC entity into which it had entered into a joint venture, where the DIFC Court of Appeal found strong cause against enforcing an exclusive Swiss jurisdiction clause. And here, of course, we're not even remotely dealing with that. The documents are equivocal at the very most. And everything else in our submission, looking at the matter in the round, points to Dubai, the UAE, being the appropriate forum. We could make 8 points about that. First of all, one of the parties is a DIFC entity regulated by the DFCA. Secondly, the companies, the applicants are companies established in the UAE with no connection in Switzerland, if it's being suggested that that's the convenient forum. Thirdly, the events giving rise to this dispute took place within the UAE. and any witnesses are likely to give evidence in relation to the dispute will be located in the UAE, and if there were a need for expert evidence, it's likely to be from UAE-based experts. Fourth, the likely dispute will be based on breaches of various statutory and tortious duties which exist under DIFC law, committed by employees or agents of R1 and R2 situated in the DIFC or the UAE. And really it's far from clear whether the Swiss courts would have jurisdiction over at least some of those disputes, and one might end up with two separate disputes going on separately. Fifth, it's unlikely that the first respondent would not seek to contest the jurisdiction of the Swiss courts in the event that proceedings were issued there. That would be a highly unsatisfactory state of affairs, to put it mildly. Fragmentation of proceedings would result. Sixth, proceedings are likely to be conducted in English. Seventh, Clause 4 of the undertakings requires the case to be determined in accordance with the laws of the UAE as applied by the DIFC courts and the DIFC courts. And eighthly, the jurisdiction clauses in the subscription agreements are non-exclusive and envisage that proceedings may be brought in the location of the Swiss branch with which the business relationship exists, which is plainly, in our submission, in the DIFC. So for those reasons, in my submission, the jurisdictional challenge made by the respondent should be dismissed, and you should rule that there is jurisdiction for any number of reasons, applying that low threshold. Moving on then to the merits of the disclosure application, and I'm going to take this very swiftly because I know that we're going to be short of time. Your Honour has a draft order at well, it was tab 4, but unfortunately that was missing a page, so we've added a further version at tab 18, which I hope you have in your bundle. Tab 18 sets out the draft order.
18 of the same.
Tab 18 of section 3. We added it yesterday, I think, and you'll see in the, so it's begins at page 504, and there was a page missing from the schedule in the other tab, so we've just added the whole document again. It begins at page 506, and you'll see that what we've done is divide up the class of documents sought into 3 classes: documents which may assist the applicants to identify the respondent entity with whom the banking relationship was properly formalized, and then over the page at 507, documents which may assist the applicants to identify the professional services performed and advice given by the respondents, and at class 3, documents which may assist the applicants to identify whether the third and fourth respondents were employees of the first and or second respondents at material times. And then going back, if I may, to my skeleton at 87, I've set out at 24.48 what is required to be shown: that the respondent is likely to be a party to subsequent proceedings, the applicant is also likely to be a party. The proceedings, the court would make a document production order in due course if proceedings had started, and then set out the leading English authority which has applied a Black and Sumitomo 2 criteria: the jurisdictional thresholds and the discretionary threshold. And to an extent, we've dealt with the jurisdictional thresholds already, and perhaps I can just invite Your Honour to read through again in due course, if it's challenged, the matters that are set out in paragraphs 89, which deal with likely to be a party to subsequent proceedings, reminding ourselves, of course, that that doesn't mean that proceedings are likely to have begun. You've already made that point. It's the parties that are, the likely refers to parties. and then the requirement the party would make an order at 89B, and the requirement that production be desirable at 89C of my skeleton. If the jurisdictional threshold are satisfied, the court is then required to move on to the discretionary stage, which I think is at the heart of the submissions made by the respondents, perhaps. And what we say about that begins at paragraph 92, or 93. We submit that the jurisdictional thresholds are met and that the factors relevant to the exercise of the court's discretion weigh heavily in favour of making the order. And again, we've dealt with the jurisdictional thresholds at 94, and then coming on, I'm sorry, to the discretionary ones. We say this, first of all, this is 94B1. The categories of documents being requested are plainly relevant to the contemplated claims. They're documents, first of all, class 1 documents, such as client account openings and onboard forms, which will assist the applicants in identifying the ambit of their banking relationship. Then they're then class 2 documents and class 3 documents, as I've taken you through. They're plainly documents in the possession, custody or control of the respondents. That's, I think, not an issue. And we see from the statement, helpful statement of Mr. Lyons, that he confirms that all of those documents are held by either by R1 or by R2, and R3 have confirmed that they hold relevant class 3 documents in the statements of the set 3rd and 4th respondents. And I've taken you to it already, but the additional terms which I took you to, that paragraph 2.1 and 2, I think it was, make clear the extent of the interrelationship between R1 and R2, and R1's right to access customer information held by R2. In essence, the reality is that R1 has practical control of any documents held by R2 for the purposes of making any order that you make. So we say the jurisdictional thresholds are made out. And then turning to 96 of my skeleton, to the discretionary stage, we say, first of all, there can be no serious or credible argument that the court should refuse the application on arguability grounds. We've dealt with that already and referred you, of course, to what is said in Smith about that. We set out at B why we seek disclosure of documents at this stage, and then at why we say that not only are they highly relevant, but the request for disclosure is proportionate. They relate to particular investments. It's not a fishing expedition asking for everything. They're specific investments and services provided by the respondents to specific clients and within a specific time frame. A focused request relating to documents which we know the respondents hold and are able to provide, and markedly different, we would say, from a case where a bank or financial institution is being asked to disclose documents relating to unspecified transactions or to transactions with third parties. This is quite the opposite, we say, of a fishing expedition where the net is cast widely but aimlessly in the hope of catching something which might help. We sought in the draft order to specify insofar as we can precisely what it is we require. The proportionality of the applicant's request, of course, falls to be determined by reference to the nature and complexity of the claim. And these claims involve mis-selling of complex financial instruments and the advice which was given or not given to the applicants. and as I've said already, the value of these claims is potentially very significant indeed, and that has a bearing upon the proportionality arguments which may be raised. And of course, the reason that it's made now is because not only may it save costs, but it may save costs in due course. Early disclosure often assists in narrowing the issues between the parties and avoiding some of the unnecessary costs of litigation. For example, it will allow us properly to particularize our claim, avoiding the need in due course after disclosure in the ordinary course of events, potentially to have to amend the statements of case, possibly avoiding the need to commence proceedings against wrongly joined parties, and facilitating the resolution of the dispute outside courts. If we have disclosure now, then a potential resolution may be able to take place in the absence of court proceedings. And costs will essentially be cost neutral, because this is an exercise which is going to have to be dealt with in due course, and may be cost saving if costs are saved in terms of avoiding the need for amendments to be made in due course. And although it's said by third and fourth respondents that their documents that they hold, contain private and highly sensitive information, we're not told what that is. And if that is the case, then of course they can be easily redacted to remove private and highly sensitive information. And it's in the interests of justice, we say, to make an application for pre-action disclosure in this case, in these circumstances. And in the absence of disclosure, as I say, there's a real risk that we wouldn't be in a position properly to plead a fully particularized case, and costs would be incurred in so doing. Now I need to deal with one other contention which the respondents make now, if I may, and that's the fact that proceedings are on foot because a claim form had to be issued, a protective claim form had to be issued during the course of our waiting for the decision, and that was issued in a standstill agreement entered into by the parties on the 22nd of March. It was plainly understood by all of the parties that the effect of the standstill agreement would be to preserve their respective positions with respect to the PAD application as well as the substantive proceedings. And Mr. Lyons, his witness statement now suggests, and it's expanded upon in my learned friend's skeleton, that an argument is to be made that the court no longer has jurisdiction to grant the PAD application. We would suggest that argument is misconceived for two reasons. First of all, it relies upon English authorities where the regime is different. The statutory framework in England under the CPR is different from that which applies here. The English authorities, in particular PMS, Personal Management Solutions Limited, concern the distinct statutory framework which applies to the CPR. And at 103B, we've set out where the jurisdiction derives from in England, section 33(2) of the Senior Courts Act, on the application of a person who appears to the High Court to be likely to a party to subsequent proceedings. The court may make an application for pre-action disclosure. In other words, in England, the power exercisable by the court is expressly limited by statute to situations in which a person is likely to be a party to subsequent proceedings in that court. And that's not the case. And there's a couple of paragraphs from PNS are cited which makes clear that that is what is the basis of that decision. By contrast, the DIFC powers with respect to disclosure is considerably wider. Article 34 of the DIFC courts, and you find that in the authorities bundle, but we've cited the relevant passage in subparagraph E of paragraph 103 of my skeleton if you have it. It's in the authorities bundle at tab 58 at page 911. The DIFC court may, on the application of a party or on the DIFC court's own motion, require the attendance of any person as a witness and the production of any documents. It's the applicant's primary position, therefore, that the court may determine the PAD application, which was issued before the administrative step of issuing a protective claim form was taken, and which the parties have agreed must be finally determined before any claim can be served, in the normal way. In any event, even if we were wrong about that the court doesn't have that wider jurisdiction, which doesn't apply in England, the court still retains a power to order production of documents outside the regime created by Rule 28.48, because, as Your Honour will know, Rule 28.55 of the RDC provides that 28.47 to 54, so including 28.48, do not limit any other power which the court may have to order production of documents before proceedings have started, and production of documents against a person who's not a party. And 28.52 goes on to provide that the court may at any time, stressing the words at any time, request a party to produce to the court and to the other parties any documents that it considers to be relevant and material to the outcome of the case. That, in fact, even in PMS at paragraph 19, is an approach which has been accepted as permissible even in the more restrictive framework applied in England. If you look at paragraph 19 of PMS. So I submit that the court should exercise this power if there were good grounds for the order before the technical issue of the claim form, then those grounds continue to exist and the court has ample power to do so. And to refuse on some kind of jurisdictional basis, on the basis that a protective claim had to be issued, would be to allow the respondents to take advantage of delay, part of which I think it's conceded that part of that delay of which was of their own making, and we say, I know it's contested, none of which was the fault of the applicants. And so for all of those submissions, we would invite you to make an application, make an order for pre-action disclosure in the terms of the order which is set out at tab 18 of section 3. Your Honour, there are a number of other points I make at paragraphs 104 onwards in the skeleton to the end, which I haven't made orally, but can I leave Your Honour in due course to read those, because I'm concerned obviously about the time.
Yeah, I do see them. It's including many authorities, a couple of authorities you're referring to.
Yes, Your Honour, those are my submissions on jurisdiction and on why you should make an order, unless I can assist Your Honour any further.
Thank you very much, Mr. Counsel.
Your Honour, thank you.
And before I turn to Mr. Musk Smith, maybe we shall take 10 minutes break.
Yes, I'm certainly happy to do that. I'm slightly concerned about the amount of time that I've got left to me to deal with the application, but
well, Mr. Counsel have gone for 1 hour 15 minutes, isn't it?
Yes.
So you probably can have that. I would give the registry the instructions to.
I'm grateful. Thank you.
To hold you and stay stand with me.
Thank you.
Thank you.
So 25 past the hour?
Yeah, we will come. Yeah, 25 plus 15.
Very good. Thank you, Your Excellency.
Thanks for your patience, Mr. Mushk-Smith.
My patience is not an issue, Your Excellency. Your patience may be by the time this hearing's over, but I shall try and be as brief as I can. And to that end,
We're
you've
all
already
at
got,
your hand now.
I beg your pardon?
We are all at your hand now. At your
Well,
mercy of the time management.
That's my mercy. I see. Yeah. Yeah. I'm not sure that's accurate, but in any event, let's hope it doesn't feel that way. All right. So to try to get through this as fast as possible, we've obviously used half the day for the stay application. What I was proposing to do, you've already got my submissions on jurisdiction. So you've got my skeleton. You've heard me. I know it was a long time ago. And I summarised those grounds, but I don't propose to go over them in detail. I think I'm worried that I'm going to run out of time on the substantive application itself. So my aim right now is to deal with the substantive application, and then if I've got time, I'll just circle back and pick up a couple of points that my learned friend makes on the jurisdiction application and summarise it and show how they interlink, because some of the issues are slightly interlinked. There's this issue of jurisdiction agreements, for example. There's this issue of whether or not there's a prima facie case. There's this issue of the so-called single entity argument. I say that is an incoherent submission, and you shouldn't be led into error by it. But it features in both arguments in relation to jurisdiction and in the substance. I was going to then start with the substantive application for pre-action disclosure, and the first problem is the one that my learned friend finished on, which is that this is not pre-action. And that is really the end of it, because the result of that is there's no power for Your Excellency to make an order under Rule 2848.1, which is the rule that we're looking at. So just to remind Your Excellency, I don't know where you're looking at the rule. If you've got a book which has it in it, it's 2848.
I got the book that got your name on it, yes.
There are many others, increasing numbers by the sounds of it, but that's one of them. Paragraph 2848 obviously requires, as subsection 1, that the court may only make an order where the respondent is likely to be a party to subsequent proceedings. So the problem for my learned friend is if the proceedings have already been issued, that requirement cannot be satisfied. So there's no power to make the order, and it doesn't matter whether the proceedings come before or after the application. What matters is whether they come before or after the hearing and the order. In other words,
subsequent proceeding mean subsequent
to the so you can only make an order. As in, you can only make an order, say you were going to decide this today, you could only make an order today under this rule if there were likely to be subsequent proceedings that followed and came later. And you're
saying the proceeding today is not subsequent, but it's existing one.
Yeah, exactly.
Is that what you're saying?
Yes, so they've issued the claim.
What's the term, and what's the definition for proceeding?
The claim, that's the claim. That's the claim. So the basis of the application today has to be that we want documents to help us with a claim that we will issue in future.
In your opinion, proceeding is a claim or a case? That's it.
Yes, that's what it means. Yeah, proceedings. So subsequent proceedings. So that means a claim that's going to be brought. Because if you look down, you can see that is what it's talking about. It's talking about the substantive action for which documents are sought. So paragraph 2, the applicant is also likely to be party to those proceedings, and then if proceedings had started and so on. So I think, and this has been looked at in England. The identically worded rule in England has been looked at, and I think my learned friend would accept at least this much, that the position in England for the equivalent rule 3116 is that pre-action disclosure would not be available in this case because the claim has been issued, even though it was issued after the application. There are three. We've produced 3 authorities on this. I think there are others as well, but we don't need to look at them all. But we should look at least one of them and possibly Yes, we can just get away with looking at one of them, I think, which is the case that my learned friend mentioned.
So, Mr. Matexman, in your submission, have you make any submission in regard of the definition of a proceeding, the one we're discussing now, or just were you just reacting to my questions?
So we make. I was just reacting to your question.
Okay. Yeah.
Because my submissions on this are quite short, and you find them in my skeleton at paragraph 54 to 57.
Right. So this is just a new one. Yeah.
Well, it's not a new argument. This argument is, we've been running this argument since we had the opportunity to respond after the proceedings were brought. As you'll recall, proceedings started while we were waiting for judgment on jurisdiction. Judgment on jurisdiction came out. There was then a period. There was then directions for exchange of evidence, and we took the point in the responsive evidence. So it's not new. It's out there. And it's explained in my skeleton argument, and it's based on a line of authority in England which analyses the equivalent rule in England. And the answer to those, to the question, once proceedings have been started, can you nevertheless make a pre-action order for disclosure? The answer is no, absolutely not. And there's a series of cases which say that. So the first one is personal management solutions. And let's look at that. That's in bundle I, tab 38. And if you go to page, maybe it's not. I think it's 673. If we go to page 673 and start at paragraph 14, this is the judge saying, I consider that the Deputy Master was right to hold that he didn't have power on the 2nd of June 2015 to make an order under CPR 3116 for disclosure before proceedings have started, when proceedings had already started on the 5th of March. And he explains his reasons. And he reminds himself of the general rules for disclosure where proceedings have been brought, refers to 31.5, identifies the usual time for disclosure, and 31.12, which allows the court to make an order for specific disclosure. And those are, of course, rules which we have in the DIFC in one form or another. In relation to production. And then paragraph 15, these general rules only apply in the context of proceedings which have been brought. It was obviously thought desirable to provide for the possibility of disclosure before proceedings were commenced, and that is plainly the reason for the enactment of the present section 33.2. 33.2 is expressly limited to orders for disclosure being made before the commencement of the relevant proceedings, and the reason for that is the powers conferred were simply not needed in relation to applications made after the commencement of proceedings. The intention appears to have been that section 33 and CPR 3116 would apply at the pre-action stage, and the other provisions of part 31 would apply in the course of any action brought. And then goes on to explain that what matters is where the proceedings of what is the status of the proceedings as at the date of the order. And it goes on to paragraph 18. I won't read it all because we haven't got enough time, but the relevant passages there are paragraphs 14 to 19. So on the English rule, which is in identical terms to the DIFC rule, there's no jurisdiction, and by that I mean power, not territorial jurisdiction. There's no power because the rule only permits orders before proceedings start. So what my learned friend has to say is that the rule works differently in the DIFC for some reason. And the reason he gives for that is he cites the English legislation on the basis of which the English rule was created. And you've seen the reference to that in the case, which is section 33.2 of the Senior Courts Act. We can see that he cites it in his skeleton argument. But just pausing, we see reference at paragraph 16 to that statute. So my learned friend says, well, it's important because the reasoning is based on that statute. But actually, when you read paragraph 16 of this judgment that we've just been looking at, the point that is simply being made is that the court is expressing its views as to the rationale behind limiting the power to pre-action disclosure. And yes, it's limited in both the statute and the rule in England. Now, my learned friend says, oh, well, it's different in the DIFC, because the underlying statute in the DIFC in the court law permits a broader range of disclosure. And my point in response to that is completely irrelevant, because we are looking at the rule. We're looking at what the rule requires. So if you turn to my learned friend's skeleton argument, where he makes this point, you see he reproduces there the relevant section of the law, which is at page 36. Do you have that, of his skeleton? It's under little b. It's paragraph 103, little b.
1 second.
If you're doing it online, it's F88.
Yes, paragraph 103, little b.
Yeah, so
Right.
my learned friend's argument is, well, the English rule is based on a particular provision of English legislation, and he reproduces that legislation, and you'll see paragraph 33, article 33, that is, or section 33 of the Senior Courts Act, powers of High Court exercisable before commencement of action, little 2, on the application in accordance with rules of court of a person who appears to the High Court to be likely to be a party to subsequent proceedings in that court, the High Court shall, and then it say have specific powers. So what my learned friend's point is that, well, the legislation in England is limited to cases where a person appears to the High Court to be likely to be a party to subsequent proceedings. And the the DIFC legislation isn't similarly limited. But the problem for that submission is that what matters is what's in the rule, not what's in the legislation. So if the effect of what my learned friend is saying is that, well, the legislation is broad enough that the rule could have been wider. But actually, if we go to the rule is in the same terms as the English legislation, which requires that the respondent is likely to be a party to subsequent proceedings.
Mr. Montague-Smith, are you saying like the rules relating to a production of document before proceedings start should come under that subtitle where it said production of document before proceedings starts, RDC 2847 till 2850, and that's the only RDC part deals with this. The claimant, claimant attempts to jump into 2855, which comes under another title called rule not limited to other powers of the court or the production of document. It's something he could not rely on because it's dealing with a different matter. Is that what you're saying?
I'll come on to that. That's misconceived as well. But just the starting point, my learned friend's argument is that you have power under this rule.
He said it's discretion, yes.
But my point is this rule is based on the English rule. It's very clear what the English rule means. This rule was implemented in the DIFC, just like all the other court rules were implemented in the DIFC, to map the English rules for a number of reasons, one of which was so that everybody knew where they stood with relation to these rules. And so you see,
but until then, I mean, do we have like this is bold subtitles between the RDCs? Do you want to call that is a binding subtitles or dividers between the rules? Or it's very hard to have that, isn't it?
Oh, you mean the headings?
To the headings, subheadings.
It's partly about the headings because that tells you what is intended, but it's also just about the terms of the rule because they require subsequent proceedings. And that, I mean, I think my learned friend accepts that when you look at it in section 33 of the English Act, those words mean you can't do it when the claim's already issued. So my point is, well, the same words in the rule must mean that as well. And also they're based on the English rules for a reason, because we were intending to follow the English rules. And the English rules mean...
Is it crucial for you that the wording, the court may only make an order?
Correct.
Isn't it?
Correct. So your powers, your hands are tied.
Yeah.
Your hands are tied if there are existing substantive proceedings. And so you're right. What my learned friend does then, if he's wrong that there's a different rule in the DIFC, he says, okay, well, I can do something different. I can bring a different application effectively. And as you say, he points to RDC 2855. Now, 2855 does not create a power to grant pre-action disclosure. It simply preserves other powers to make those sorts of orders. Now, there are other powers at common law, and those have been acknowledged in the DIFC. In particular, what's known as the Norwich Pharmacal jurisdiction, which is where a party is mixed up in somebody else's wrongdoing. So they're actually a non-party to the proceedings. That's an example of a substantive right or power to order documents, which isn't within the express rules of the court and exists even though there are these other rules. However, my learned friend doesn't put them on that basis. What he has to do is find a power, another power. Now, he says actually in terms in his skeleton argument that he applies under 2852, which we have to go back, but that's misconceived because that's about non-party. That's about non-party disclosure.
Yeah, what about he also referred to 2848.3.
48.3, but that, yes, but 2848, all of it requires, these are cumulative requirements in 1 to 4. So you have to satisfy all 4 of those tests.
If proceeding had started, the court would make a document production order directing the production of the document or classes document of which the applicant seeks production.
Yes, but he has to satisfy all 4, 1, 2, 3, and 4. It's not 1, 2, 3, or 4. So if you see after 3, it says and. So to get pre-action disclosure, he has to satisfy all 4 of those requirements. So if 1 is missing, then he can't. Your Excellency has no power to grant him the order that he wants. So that's why it says we focus on 1 for this purpose, because the respondent has to be likely to be a party to subsequent proceedings, and this is therefore confined to the situation where you are before issue of the substantive set of proceedings of the substantive claim. I mean, what he actually recites in his skeleton argument is a different rule altogether, which is, I think, 2856. Because I think that's the one that he's quoted in his skeleton argument. And that one says the court may, at any time, request a party to produce to the court and to the other parties any documents that it considers to be relevant and material to the outcome of the case. Right? So that would mean that his pre-action disclosure application has to be material to the outcome of this case. Not the one that's not the substantive set of proceedings, but this case. So that's why we say it's misconceived, because the proceedings that he wants the documents for are a different set of proceedings, a different claim. That's the claim form. You'll find it at bundle B, page 499. But those are the claims where he says, well, this is where we get our money claim off the ground. He needs to show that the documents under this rule are relevant to this claim for pre-action disclosure. That's why it doesn't work, because we're doing that hearing now. So if he wants to make an application for under this rule, he needs to do it in those other sets of proceedings. Now he can't do that now because he hasn't served those proceedings, and in his words, in his skeleton argument, he says it's effectively stayed. So he's not in a position to make an application in that other in that other claim. He can only make an application in this claim. This claim is for pre-action disclosure. That means that there are no documents relevant and material to the outcome of this claim, which are the subject of this claim. It's completely circular and totally misconceived. And the third point is, well, he hasn't actually made that application at all. There isn't an application on foot. And so Your Excellency's instinct, if I can put it like that, was correct in this regard. This is a misconceived application We say it always was, but it is now that there's been issue of proceedings. If he wants to make that application, it would have to be an application in the substantive proceedings. It can't be an application in these proceedings. But in any event, there isn't an application in these proceedings. And that's it. That's the end of the application. There is no answer to that point. And in a sense, you don't have to go on from there and look at all the other problems in the claim for pre-action disclosure. But obviously, I'm going to go on and do that. And so that's the first problem. The second problem with the case is that the claimants fail anywhere to set out a prima facie case. And my learned friend says he doesn't need to do that. We say that is just plain wrong. That is a surprising submission. And I need to try and do this as quickly as I can, but it's quite crucial. And I just take you to a few of the short passages in the authorities. You have in the bundle, and I won't take you to this, but I'll give you the reference. You have in the bundle a copy of the relevant extract of the White Book, which the White Book, obviously, you know well, is the commentary on the rules. And you will see at page I, tab 53, page 873, that there is reference there to the principles set out in two cases. They're identical, effectively. One is called Asset Co, and one is called Carillion. So I'm going to take you very briefly to both of those. And it's very short passages. It's I, tab 34. And if we go to page 6, that starts at 601. But if we go down to page 604, right at the foot of the page, paragraph 17, the law applicable to the application is not materially in dispute. Rule 3116 provides that the court may make an order for pre-action disclosure only if certain conditions are satisfied, goes through those conditions, and then if I just ask you to look at 5, the anticipated claim must have a real prospect of success, quoting Court of Appeal Authority of Rose and Links Express. 6, finally, it's important to keep in mind that certainly in the commercial context, a pre-action disclosure order, even if not exceptional, is unusual. I note that to you just because I don't want to have to come back to this, but for the purposes of this submission, real prospects of success are required. Next case, Carillion, which you find at tab 44, and page 784 it starts, but if we go to page 800,
what's the reference again?
I tab 44. Oh, let's start at 788, please. Again, I'm coming here just because we're in the document.
Yeah.
But you'll see applications in the commercial court. Applications for pre-action disclosure in the commercial court are relatively rare, and the authorities to which I was referred contain no recent examples of successful applications. 2018 edition of the White Book said that pre-action disclosure orders are far from a foregone conclusion, especially in the Chancery and commercial courts. And in Hutchinson 3G, Mr. Justice Steele said that in order to obtain pre-action disclosure, the circumstances must be outside the usual run, and the absence of any convincing grounds for distinguishing the case from the normal run would be telling grounds for not exercising the court's discretion in favour of pre-action disclosure. And then refers to Asset Co, in which Mr. Justice Blair said that it was important to bear in mind that certainly in the commercial context, a pre-action disclosure order is, if not exceptional, unusual. So I draw that to your attention. But the point that I wanted to make on prima facie case is at 800, page 800. And you'll see at paragraph 66, little v, again, reciting the principles by reference to Asset Co, the anticipated claim must have a real prospect of success. Let's carry on. Mars UK, which you'll find at tab 22. It's a slightly earlier case, page 422. Paragraph 5, it seems to me that before the court can make an order for pre-action disclosure, the application must show a prima facie case that is entitled to relief by way of, in this case, passing off, so the substantive claim. If that were not the case, in the context of passing off, an order would have to be made in all circumstances where competing makers of a given product compete with the public for sales of that product. There's reference to Black and Sumitomo, which my learned friend says is the leading case. And paragraph 7, that passage in the judgment of Lord Justice Ricks was advanced in support of the applicant's proposition that it was not necessary for an applicant for pre-action disclosure to show a prima facie case before coming to the court for an order. It does not seem to me that that passage in Lord Justice Ricks' judgment is authority for such proposition. And then I think the last one that I want to show you on this is Gwell Hale, which you'll find at tab 29. And if we go to page 529 of the bundle, and it's really paragraph 8 of the judgment, it's important to highlight what the cases have said about the court's investigation into the merits and the clarity of the underlying issues of the claim that might one day be brought by the applicant against the respondent. In that connection, I note the following. A, passage from Bermuda International Securities and out above, in which LJ said that the court must be clear what the issues in the investigation are likely to be. 2 further passages in the judgment of Lord Justice Ricks, in which at paragraph 71 he made the point that for jurisdictional purposes, the rules require that the parties concerned in an application were parties who would be likely to be involved if proceedings ensued, but that did not mean to say that the proceedings themselves had to be likely. I'm sorry, I don't want to read the whole thing because I don't want to spend all of my time doing that.
I'm taking note of that, yes.
I'll show you C, Snowstar Shipping. The more speculative a claim, the less inclined the court is to grant the application, and its weakness is a factor which I take into account when considering whether a pre-action disclosure order should be made. And then D, which is the Rose and Links case, which I mentioned which we saw was mentioned in another case. A court should be hesitant in the context of an application for pre-action disclosure about embarking upon determination of substantive issues in the case. Accordingly, it normally be sufficient to found an application under CPR 3116(3) for the substantive claim pursued in the proceedings to be properly arguable and to have a real prospect of success, and it would normally be appropriate to approach the conditions on that basis. And then talks about reference to summary judgment, and E should take a broad view. I accept that. And if we go down then to page 533, paragraph 20, as I've indicated, the high point of the proposed claim is the suggestion that Gwell Hale may wish to investigate Bailey's role in the project, and in particular in relation to the final account. With respect, civil litigation does not consist of an investigation simply for its own sake. The investigation carried out by the court is only that which is necessitated by the claims that are made in order to see whether those claims are made out or not. It is therefore the underlying financial claims that matter in the present case. As I indicated, no such claims are indicated in the documents. And refer you also to paragraph 27 on page 534, the bottom of the page. I'm unable to conclude that there will be a claim at all, let alone a claim with a real prospect of success. In those circumstances, it seems to me that whatever the jurisdictional position, I should not permit this application, and on to the end of that. So my learned friend relies on a case called Smith, and he says, well, I don't need to show any of this. And none of what I've just shown you is changed by Smith, because those other cases are referred to in the White Book as being accurate. In Smith, the issue was whether or not arguability went to the discretion phase or to the power phase. And actually, the Court of Appeal said in terms it doesn't really make much difference, because if there's an unarguable claim, then you're not going to get your order, however you analyse it. The references to that are and I won't take you there. Bundle I, page 621, paragraphs 22, 23, and 28. But the point is, you still have to articulate a case. Otherwise, you are unable to show that the documents that you are seeking will be relevant to an issue in the claim. And that's a required jurisdictional power requirement under 2848(3). So what you can't do, as we've seen from Gwell Hale, is say, well, there's a potential case we need to investigate. It's not about investigating the relationship to see whether there's a claim there.
So Smith, when you're saying the claimant has to articulate a claim, a prima facie claim, you're saying this, and I'm a bit confused. In the first or in the alternative case, whether this is a pre-action disclosure or even after action disclosure, or in both cases?
So when you say that it, so my first point was we're not pre-action, so you can't have an order, but I'm moving on to that. So assume there's not a problem there.
But even
the
if
next,
we,
the next question is, assuming you've got the power to do it, does my learned friend need to establish that he's got a prima facie case, a case that makes sense at the first instance?
Yeah, I see.
And the answer is he says he doesn't. I'm showing you the authorities which say he does need to do that. And part of the reason for that is because before you can exercise the power, my learned friend has to persuade you that the documents he seeks will be relevant to the issues in the claims. So you need to know what the issues would be in the claim. And to have issues, you need an assertion which is denied. And they're going to go to the facts because they're documents. And so you need factual disputes effectively. And if you don't explain what your case is properly, you cannot do that. And you see this issue arise.
This is the test for post-action, I mean, production, isn't it?
Yes, exactly. So that's recited in 2848. So 2848(3) requires that if proceedings had started, the claimant would make a document the court would make a document production order directing the production of the documents or classes of documents for which the applicant seeks production. And the only way that the court is going to do that is if those documents are material to an issue in the claim. And so unless you explain what those issues are, you can't satisfy that requirement. So it goes to jurisdiction to that extent. And you see applications being rejected for that specific reason over and over again. So the two that I was going to take you to, there's one at tab 20, which is Bermuda International. If you go to page 398.
I got it, yes.
Paragraph 398, paragraph 26, about 6 lines down, the circumstances spelt out by the rule show that it will only be ordered where the court can say that the documents asked for will be documents that will have to be produced at the standard disclosure stage. It follows from that the court must be clear what the issues in the litigation are likely to be, i.e. what case the claimant is likely to be making and what defence is likely to be run, so as to make sure the documents being asked for are ones which will adversely affect the case of one side or the other, or support the case of one side or the other. And you see it also in a case called Hart, which you find behind tab 47, which is a more recent case, a decision just from May, in fact, in case it be said that this is all out of date. So page 842 of the bundle. You see there the primary difficulty with the application is the requirement to demonstrate the relevance of the documents sought to the issues in the case.
What page number was the
842?
842. Yep.
So the primary difficulty with the application is the requirement to demonstrate the relevance of the documents sought to the issues in the case. In this application, it's not possible to analyse the relevance of the documents by reference to the pleaded case because there is only the very briefest description of the claim on the claim form, and the particulars of claim have not yet been prepared pursuant to the agreed stay between the parties. And then paragraph 18, the limited explanation of the claim on behalf of the LSOs puts the PO applicants in some difficulty in addressing relevance of the documents to the issues in the claims. As the CPM has identified, it is difficult to satisfy this requirement where there's been neither pleaded case nor properly particularised letter of claims. That makes the relevance of documents sought difficult to identify. So again, you've got to spell out the prima facie case, because if you don't, you can't get through the various stages. One way or another, my learned friend has to explain what his case is and why it gives rise to factual issues which will be answered by these documents. So my learned friend says on this, in his skeleton argument at least, that the test is whether or not it's beyond argument that you have this power. But that's the test that you decided was the jurisdictional test, the territorial jurisdiction, not the test that applies at this stage when you're dealing with the pre-action disclosure application itself. He has to persuade you that he satisfies those tests. And the problem that he has here is that he never really articulates his claims. And so let's have a very quick look at what he says. There's a lot to be said about what goes on here, but there's limited time to do it, so I shall do as much as I can. So page 40 of his skeleton argument, it's on page F92 of the bundle. he sets out to describe the claim that he's going to be advancing, paragraph 110. He says, it's a claim, this is the third line down, an intended action for mis-selling of financial products. And then he says, besides the contractual claim, the applicants are likely to pursue claims arising out of breaches of, and goes on. So start with the contractual claim. What is that contractual claim? What is the term of a contract which has been breached? What has my client done, even potentially, to breach that term? He hasn't once identified a single term of a contract which he can say, well, we want to investigate whether in fact that contractual term has been breached. And the evidence, and when it comes to the tort claim, there's some vague assertions that maybe it's got something to do with advice, giving advice. But as we'll come to see it, actually his evidence is no advice was given. So you can't get a tort claim off the ground on the basis of advice. And then on the regulatory allegations, I'll come on to those in a moment. I say they should never have been made and shouldn't be maintained in the way that they are. But the evidence which is actually provided is just as vague and unsatisfactory. And I'll take you to that very briefly. It's behind tab B, section B, tab 2. So this is Miss Sheffield's first witness statement. If we go to page 38. This is really the heart of where this all comes from. And what she does there is she simply names causes of action. So she says, in light of the foregoing, one or more of the respondents are likely to be named as defendants in the following potential claims brought by the applicants. A, in tort, codified under the DIFC law of obligations, including professional negligence by providing negligent investment advice, and or B, 2, negligent misrepresentation by representing untrue information about the fund and its performance or being reckless as to its truth. But she never actually identifies any factual statement or any advice. They must have received the advice to have an actionable claim on it. They must be in a position to say, on X date, we went to a meeting and somebody said why. If they can't do that, they can't get a claim off the ground. They must have that advice to be able to have, for them to have relied on it. And instead, what we get is simply, well, there's going to be a claim in tort, and there might be a claim for breach of DIFC law. The breach of regulatory law, I just will come back to it. You'll see it B2 is said to be by arranging deals for which the respondents appear to not have been licensed. Now, that's not actually, as I understand it, something. My learned friend gave you a list of problematic breaches that there might have been. He's never identified a regulation that's been breached, but in his oral submissions, he said, oh, well, there might be all these other things. My client, the first defendant, was licensed to arrange deals in investments. There's no case, well, there can be no case, that some account was opened with the first defendant. And all of the contracts, as we'll come on to, are with the second defendant, save there was some involvement in 2013 before these investments in relation to accounts opened in Switzerland and Singapore, which have nothing to do with the funds at all. They're quite separate and they're being mixed up, and you're being shown emails relating to the 2013 accounts, and they say, oh, well, there's involvement of the first defendant here. And you have to be careful not to get confused, not to confuse that with the allegations relating to the funds, because those investments came 2 years later and have absolutely nothing to do with those communications. And then we have the third witness statement. That's the evidence. That's really the heart of the way it's put. And then we have Ms. Sheffield's third statement, which you find behind section C, tab 6, page 55. And you see how it's put at paragraph 26. in particular 26.1. So it's just said claims for breach of contract. It's page C55. She says, well, there might be claims for breach of contract in respect of any express or implied obligations owed to the applicants in relation to their investments. The precise scope of these contractual duties is likely to be informed by disclosure of the classes of documents referred to in Sheffield 1. Now, I mean, contractual terms, you will find in contracts. They have the contracts. They can't point to any terms. But what this evidence shows is that the claimant just isn't able to identify a contractual breach of any sort. And the other two descriptions you have there are again similarly vague and broad. So we say the pre-action disclosure application does not even begin to get off the ground against any of the defendants because no claim is ever spelt out. It is the very definition of a speculative claim. The best that they can do is say we entered into these contracts, we suffered a loss, we think the defendants might be liable for it. We want to trawl through all of these documents to see whether we can find something that helps us do that. That's the classic fishing expedition. So that's the first point. The second point is that if one looks at these claims, these potential claims, breach of contract, tort, regulation, none of it could possibly work anyway. Even if you give them the generosity of saying, well, they don't actually have to explain it. So if we take it in stages and start with the contractual claim, fundamentally, what you've got are a series of contracts between the claimants and the second defendant. So some of those were for subscriptions to shares, some of them were for loans, and then there's a pledge agreement by which the shares were pledged as security for the loans. It's not an unusual banking relationship, but just I ought to show you a copy of a subscription agreement just so you have it in mind what we're dealing with here. So not complex documents. Bundle B, tab 3, page 253.
Bundle C.
B.
B, okay, B.
B, yeah, B 253. That is an example of a subscription agreement into the, you'll see, Dana GCC Equity Fund. And you see it runs to about a little over 1 page. All of the terms really are in the first page. And the substantive aspects of it, you'll see in the middle, about the 4th paragraph down, the subscriber hereby authorises the bank, and you'll see that's the second defendant that's named, to execute orders relating to the purchase, sale, transfer, dealing in, as well as deliveries or receipt of the units in the fund in the bank's name, but for the account and at the risk of the subscriber for the above referenced account, custody account. So all they are doing is agreeing to execute the, in this case, Sari Investments, which is the third claimant's instructions to execute investments in the fund. That's it. And you see actually that there are related fund documents, but then at the bottom you see there's a general disclaimer there. The bank's just that.
This paper is referring specifically to the Dana GCC Equity Fund.
Yes, that's correct. So it's all the investments were in that fund. That's the investments that are the subject of the proposed claim. That's where the claimants say they lost money through those investments. And you will see, just because we're here on page 254, the jurisdiction agreement that's inserted there. My learned friend makes the astonishing submission that it's non-exclusive and might actually incorporate the DIFC. That's brand new and doesn't make any sense whatsoever, because look, on page 254, it says all legal relations subject to Swiss law, and then the place of performance and the place of debt collection for subscribers who are domiciled abroad, and the sole place of jurisdiction for all proceedings is the bank's principal place of business in Zurich, Switzerland, or the location of the Swiss branch. My own friend suggested that maybe that's a reference to the DIFC because the first defendant is involved. The problem with that is twofold. Firstly, the first defendant is not a branch of the second defendant, as my own friend well knows. A branch is a part of the same legal entity. And the second defendant doesn't have a branch in the DIFC. But even if it did have a branch in the DIFC, that couldn't be the Swiss branch. And therefore, it's simply not, I think, a fair presentation of those clauses to say somehow that they are non-exclusive and could be a reference to the DIFC. But in any event, all that the second defendant is being appointed to do here is follow the instructions of the claimant and help them subscribe to shares. Now, I mean, there is this assertion that there might be some contractual relationship with the first defendant. I think what you have in my skeleton argument at page 12 in a footnote is a reference to how all of the contractual documents are introduced by Ms. Sheffield. And they are all introduced as contracts between, on the one hand, one or other of the claimants, and on the other hand, the second defendant. So the evidence, such as it is, that comes from the claimants in relation to this, identifies the contracts as being with the second defendant, not with the first defendant. And in any event, you can see it from all of the contracts in the bundle. So there are many. There's a number of subscription agreements. There are 2 credit agreements, and there are a series of amendments to all of those agreements, and there's the pledge. All of those name the second defendant, not unsurprisingly, the first defendant. And so to get to some sort of allegation that there's some sort of claim against the first defendant, to get to this allegation that there's some sort of claim against the first defendant, some sort of contractual relationship with the first defendant, you have this argument that the single unitary entity argument, which effectively asserts that somehow they're to be treated as one and the same. That by entering into a contract with the second defendant, the claimant entered into a contract with the first defendant too. Now, we don't have time to go through all of that in any detail. My learned friend took you to some of the documentation, and I deal with it at paragraph 80 of my skeleton argument, or most of it. There's a new allegation that's been introduced since the last hearing. But just as a legal submission, it is, in my submission, incoherent. Every lawyer knows full well that you can have 2 companies in a group of companies that are distinct legal entities. Just because they're under common control doesn't mean that if you sign up to a contract with one, you sign up to a contract with all of them. As a matter of fact, they are 2 legally different entities. And this list of factors that's provided partly doesn't actually say what my learned friend asserts, but none of it supports his contention that somehow the first defendant is party to any of these contracts. So I can do this quickly by reference to paragraph 80 of my skeleton.
Well, you didn't have to run correctly, because this is one of the central things like Mr. Counsel relies on. Because you want to bring, with the involvement of R1 is the major issue for bringing the rest of the defendant into this claim.
Quite.
Or whatever, yeah.
But I mean, so you've got my overarching submission, which is that, you know, the connection between 2 parties is nothing to the point. The question is, who did you contract with? You find that out by looking at the contract, if you didn't know it before. And the fact that there are more entities in the group doesn't mean somehow you've contracted with another one of them. And I just make the point as well, the claimants knew full well who they were contracting with. And we can see that if you've got bundle B open and go to page 283. So you see there a letter from September 2016. So at this point, Sari Investments, the third claimant, has invested. And you see the letter that is sent. Who is it sent to? It's sent to the second defendant, Julius Baer and Company Limited. Nicholas Maurer, we'll hear a bit more about him. He's the relationship manager in Zurich. Transfer and closing of account 03134223. Dear Mr. Maurer, I hereby kindly instruct you to transfer all assets and loans from the Sari Investments account, the number 4223, to the newly opened account 4348 for Soor Investments. Kindly close the account after completion of the asset transfer. So they know full well who their counterparty is. It's the Swiss bank. And of course, that's what you see in all of the contracts. So what about this long list of points that are relied on to say that this is a single unitary entity? Well, let's look at these pages then. We started with page 77. And all that is, my own friend's submission is factually wrong. This is not a page from the second defendant's website. This is a page from the group's website, which lists various different entities, one of which is the Dubai and the DIFC entity, also listed as the second defendant. They are presented as distinct legal entities. It's simply a situation where it's saying, if you want to get in contact with us in relation to investments in Dubai, use them as the first port of call. That doesn't mean people are contracting with them. The second set of documents that are relied on are the ones that appear at page 88. And you will see they start from 88 and they go forward. But the first 2 pages, yes, that is an email sent by the first defendant, but it's an email sent in 2013. You see that in the middle of page 88, July 16th, 2013. And it's relating to a completely different account. How do we know that? Well, A, the investments weren't even in contemplation at this time, but B, you can see the account number is recited there. It ends 3448. That is a different account number, and you will see that from the account numbers that I just showed you in the letter that was sent from the third claimant saying, please transfer our investments between the accounts.
Are this the one meant to be closed?
No.
Oh, no, not even this.
Completely separate. This has nothing to do with it at all. So what happened was in 2013, you see who are the entities that they're setting up accounts with. So one of the things Ms. Sheffield says, oh, well, maybe the first defendant wasn't supposed to be allowing people to open accounts. Well, it wasn't allowing people to open accounts with the first defendant. It's assisting the claimants to open accounts with the second defendant. You can see that because each of those boxes, the beneficiary bank is Julius, Baer and Co. Zurich, all the way through until Geneva at the end. So for security delivery, that is. And so the idea that this has anything to do with the investments is just wrong. And then the next set of documents, which you get to further down, page 90, is all to do with the opening of a bank account with a branch, the second defendant's branch in Singapore. So in Singapore, the second defendant has a branch. And again, you can see this is from 2013, and you can see the enclosed documentation at page 97. And you can see what is being opened, although this isn't the completed documentation, is to open a bank account with Julius, Baer and Co. Singapore branch. So again, the idea this has anything to do with this application is just wrong. And you can see the extent to which the claimants are reaching to try to find any possible route to engage this court's jurisdiction, try to persuade you that there's a claim against the first defendant. But even if the first defendant assisted with opening these accounts, so what? Even if it could be said, which it can't, that they had assisted in opening investment accounts in 2015, it doesn't make them party to the contract. The next assertion.
So which contract is the fund operation, or you mean, or the contract that will be the subject of breaches?
Yeah. So well,
the investment
exactly.
ones, yeah.
Well, we don't know because we haven't been told what the claim is. But the only contractual claim that could be brought would be the contractual claim. Would be pursuant to the contract between one or other of the claimants and the second defendant. And the only contracts that there are in respect of that are the subscription agreements, which are simply the bank helping the claimant to place orders in relation to the fund. They're not running the fund, they're not managing the fund, they've got nothing else to do with the fund, they're just assisting with the subscription to the fund. And then on the other hand, the loan agreements that were entered into and that were backed by the fund units as security. So the pledge agreement that pledged that.
And that's what the claimant said. This is a very, very partially done through DIFC, isn't it?
Well, no, but they can't say that. You see, this is the thing. We're looking at we're looking at what they rely on to say that. So the first question is, and I'm taking it in stages, looking at the contractual claim first. You need to have a contractual claim. You need a contract with another party.
Yeah.
So the first question is, who's that contract with? We accept that there were contracts with the second defendant. My learned friend says, oh, well, you can just treat them as the same entity for these reasons. And we're going through those reasons and we can see actually that they don't stack up on the facts. But imagine that they did show some involvement of the first defendant in these investments. That wouldn't mean that magically the contracts become with the first defendant. You can assist somebody in entering into a contract without becoming party to it. The third item that's relied on is what is said is that the designated relationship manager was employed by the first defendant. And you were taken to a passage in Ms. Sheffield's first statement, but that was a passage, and I've recited the relevant parts. You can see it in my skeleton if you've got it at page 14, little 3. It's on page F122 of the bundle. You'll see I recite the assertions. They say that the designated relationship manager was employed by D1, referring to Sheffield 1, paragraph 15. And then, in fact, that passage of the statement expressly says at that time, referring to 2013. And she later accepts that when it came to investment in the fund, the claimant's relationship was apparently handed over from their initial relationship manager to the third and fourth respondents. So she's not actually asserting, and the evidence even that Ms. Sheffield provides is not that Ms. Al-Yazdi was the relationship manager for the investment. She was the relationship manager in respect of the 2013 steps that were taken to set up accounts in Zurich and in Switzerland, but those have absolutely nothing to do with the investments in the fund. And in any event, so again, so what if they did? It wouldn't assist in making the first defendant a party to the contract. It doesn't show that they're the same entity. They're not. And then you've got this letter, which is in bundle D, tab 5, page 111.
What's the reference again?
D, page 111, D111. So this is again said to show somehow that the first defendant is party to these contracts, is the same entity as the second defendant. But actually what you've got is at D110, the first defendant simply forwarding correspondence. That's all it shows. And when it comes to signing off...
On what basis? I mean,
simply as a convenient means of communication. Why not?
well, come on, it's an emails, you know, they're not carrying it's a bundle of, I mean, documents from Switzerland to Dubai by someone else. Well, what the Swiss bank could have sent that email directly to the client.
I don't know why it was sent in that way, but the question is,
that's why the claimant says we need to know why. Then,
but what? No, but that's not enough to say, well, there's something odd here. You need to investigate. That's not how the case works. That's not how the courts work. You have to have an allegation. The allegation has to be, in respect of this, that somehow the first defendant was a party at this stage. I'm looking at the contractual claim, a party to these contracts. What has that got to do with the first defendant forwarding an email, forwarding a letter, assisting in that? It really is just absolutely the most marginal piece of evidence one could have. So this comes after the event. This comes in February 2017, and the letter itself it makes clear comes from the second defendant. It's just passed on by the first defendant. So it's signed off Julius, Baer and Co. Limited, which is the second defendant. And you can see that the letter paper, the header on the letter paper is from the second defendant as well.
Well,
So-
problematic. It's even yourself, Mr. Muslim, could not find any reason why this come through R1.
Well, I may have missed the reason, but you can't generate a case just because there's an anomaly.
And this is
because somebody
way beyond the opening of the account. So this is towards maybe the conclusion of the funds, where the maybe what or the claim loss is articulated already, maybe by then.
Well, that depends on what the claim is, and we don't know.
Again, yes.
Actually, this was between the first and second investments, and all you have here is a letter being forwarded.
Mm-hmm.
Now, generally speaking, the first defendant does take a role in relation to certain accounts with the second defendant, but only those accounts, and this is in Mr. Lyons's evidence, only those accounts in respect of which it's providing advisory services. So it will be the first port of call. You've got the additional terms that my learned friend put so much weight on. But again, those relate to the 2013 accounts. And those say, in our communications with you, in your communications with the bank, it should be routed through us, the first defendant. But those are only in relation to accounts where the first defendant assists and advises. And there's no evidence, no suggestion that that role was taken on by the first defendant in relation to the investments in 2015. And there's certainly no evidence to support it, and it didn't happen. So I don't know why this particular email happened to be forwarded via the DIFC. But it really doesn't make any difference. It certainly can't by itself give rise to any suggestion that the first defendant was party to these contracts. How does that work? And then you've got two other arguments that are raised. The first is that the litigation has been conducted together between the defendants, first and second. Well, of course it is. They're subject. They're the part of the same group. We're not going to pay two sets of lawyers to do different things. That doesn't mean that they're a single entity. And then the other point that's raised as well, it said, oh, the document management system is common between the parties. And again, that's a wholly normal situation where you have a part of a group which is spread among far-flung places, that you have a centralized back office function. And as Mr. Lyons explained, the first defendant only has access to those parts of the record or the archives which are related to linked accounts. And his evidence, contrary to the submissions that are made earlier, his evidence is that the first defendant does not have access to any documents on the central archives related to the investments. Those are not linked accounts. They do have access in relation to the 2013 accounts. So my learned friend says, oh, well, the first defendant's got access to all of these documents. There's not a shred of evidence to support that allegation, and it's inconsistent with the evidence from Mr. Lyons, and I'll show you that in a moment. Oh, actually, it's B471, paragraph 49. So none of that gets you anywhere near some sort of contractual relationship with the first defendant. My learned friend relies then on the so-called additional terms, and you'll find those at bundle B, page 151. And I mean, it's interesting because one of the things, I mean, it's the essential reason my learned friend relies on this is to suggest that somehow no distinction is made between the first and second defendants. But what actually this document shows, if you look at page 151, is that when the first defendant contracted, the document said so. So you have, in the very first paragraph, this distinction between, on the one hand, Julius Baer Middle East Limited, and on the other hand, Bank Julius Baer and Co Limited. So the idea that somehow these terms indicate that they're the same entity, or they're acting as the same entity, or whatever the allegation is just misconceived. They make the clear distinction. So there's really 2 points in relation to this. First is these are additional terms that were entered into in relation to the 2013 accounts. not in relation to the investments. But even if they were in relation to the investments, they wouldn't make the first defendant party to the subscription agreements or the loans or the pledge or anything else. The particular clauses that are relied on are at page B154, paragraphs 2.1 to 2.5. And all those say is that the customer will communicate with the bank via the first defendant. And my learned friend says, well, that makes the first defendant an agent of the second defendant. I mean, that's a loaded term, but whatever it's doing, it's just requiring, these terms just deal with the passing on of information and communications. That's all it is. It's for very limited purposes. But even if he was right, even if there was an agency relationship that arose, you contract with the principal. The fact that I use an agent doesn't make the agent a party to the contract. And the claimants say, well, that meant that the first defendant was in charge of the relationship. That's the way it's put, but it doesn't show that at all. There's no evidence whatsoever to support that assertion. That's another loose submission, I'm afraid. So in terms of the contracts, there's no scope for a contract with the first defendant. There's no shred of evidence of a contract with the first defendant. And this concoction of points that's put together to try to say they're the same entity gets my learned friend nowhere. He doesn't try very hard to say that there's a contract with a third or fourth defendants. Of course, they were the employees, they're individual employees. It would be very surprising if there was that. I'll come back to the contractual claim against the second defendant in a moment, but just dealing with the first defendant's position and the third and fourth defendant's position on tort, the evidence repeatedly is that no advice was given. Now, if I advise you without a contract to do something, say, and take out an investment or something like that, one can imagine a world in which that could create a duty of care in tort, and there might be a claim there. But if I don't give you any advice and I just happen to be sitting in the room and you're not contracting with me, then there's no basis for a claim in tort. And I'll give you the references. Ms. Sheffield says repeatedly, no advice was given. The references are starting at page bundle B, tab 2, page 16, paragraph 24, and then she says it again at paragraph 33, and she says it again at paragraph 44. There's no advice.
You said B16?
B, page 16, yes. So at the top of the page, I'm informed by the applicants that at no point during any of the meetings which took place in respect to the fund between late 2015 and early 2016 did the respondents outline any risks associated with investment in the fund or provide any advice or analysis in respect to market trends or suggest or discuss any other suitable investment as alternatives to the funds. Paragraph 33 is on page B20. I'm informed by the applicants that at no point was any financial or investment advice provided by the respondents in relation to the subscription agreements, the undertaking and guarantees in respect thereof, the outsourced facility, or the first investment generally. And then paragraph 44, in relation to the second one, I'm the same assertion. No advice was given. So if no advice was given, there can be no scope for a claim in tort. There would be no duty to advise. There could only be a contractual duty to advise. You've seen the contracts, there isn't. But dealing with the position of the first defendant, the third and fourth defendants, if there's no contract, how can you possibly have a claim in tort if they didn't actually give any advice? In his skeleton argument, my learned friend says, oh, well, that's all an issue of fact and law and you shouldn't get into it at this point. But it's not an issue unless someone asserts it. That's why it comes back to...
But you know, Ms. Smith, I think what's in paragraph 24 of Ms. Sheffield evidence, she's trying to say, like, the respondent did not alert them about any risk. That's what it says. It's well, it's not outlining the whole course of relationship in here. I think it's where she's talking, there is no red flag by the respondent to them, which is something else.
But how can that turn into a claim? the only way that can turn into a claim is if there was an obligation of some sort to raise a red flag.
What obligation mean? They have a duty to maybe to alert them or outline the risks.
But what,
Maybe this is by other words. This is how I read it.
Where does that duty come from? It can only come from either a contract, right? But if first and third, but the general law, if I'm sitting in a room with someone who's about to enter into a contract and I don't have any contractual relationship with them, I don't have a duty to save people from themselves entering into contracts. I don't have a duty in tort unless I positively take the step to assume responsibility for their actions. If I go with you to a car salesman, you buy a car, I'm not liable if it's a bad investment. If I advise you to buy that car, well, then you might have the beginnings of a claim.
Oh, you need a positive action, yeah.
But unless you've got some positive advice being given, then where's the claim? There isn't a claim. And I mean, my own friend sort of, I mean, he says in paragraph 9 of his skeleton argument, no financial or investment advice was given. But then at paragraph 10, he says, oh, well, relying on the respondent's advice, they entered into these investments. That's inconsistent, both with his own submissions and with his own evidence, which is that there is no advice. And then
from D1 at least, yeah.
Well, but from anyone.
Yeah.
So I mean, I'll come back to D2.
Well, if they, you're not saying they don't have contract with D2, isn't it?
No, they've got contracts with D2.
And but she said D2 never raised the flag.
Yeah, but where's the obligation on D2 to raise the flag? That has to be a contractual obligation to do that. And I've shown you the contracts. They're at 1 page long. What do they say? They say, all we are doing is following your instructions. So we can't possibly, we're not giving you any advice. That's a perfectly normal banking relationship to have. Now, if you enter into a broader banking relationship, which requires you to give advice, and in the context of that, you do advise, then there may be contractual duties. And if you don't advise, then in certain circumstances, there may be an obligation to advise with the right contract in the right context. But we've looked at the contracts. My learned friend used to say, well, that's the duty to advise. That's where it arises. But he doesn't begin to make that case. And the regulatory claim is even more unfortunate in my submission, because it's asserted as a potential regulatory claim. That is a very serious allegation to be making against a bank in a regulated environment. My learned friend makes clear, he made clear at the last hearing, and I understand him to be making clear at this hearing, although it's said rather quickly, that he doesn't actually positively assert a breach of regulations by my clients. If he does, I wonder what has changed since the last hearing when he accepted he was unable to make that allegation. But even saying, well, there's a potential claim, I'm not making the allegation, is very nearly as bad as making the allegation. It is not, in my submission, an appropriate way to go about a claim like this. I've shown you the bit in Ms. Sheffield's evidence where she said, well, perhaps they were arranging deals for which they were not licensed. There's nothing to support that, and my client, the first defendant, was licensed. Obviously, the second, third, and fourth are not, because they're not DIFC regulated. But it's absolute definition of speculation. My learned friend plays with fire when he comes to a public forum and says, "Oh, there might be regulatory breaches by a major international bank." To be clear, there is no positive suggestion, still less any evidence, that anything in relation to these investments was done in or from the DIFC, or that it could be any regulatory breach. We had a series of speculation about what breaches there might be, but you've got no reference to any regulation. It's impossible to respond to those sorts of serious allegations in this sort of way. That's the first time some of them were made orally in a hearing. It is not an appropriate way to deal with those sorts of allegations. And so the third and fourth defendants are in exactly the same position. It's very unfortunate that individuals have been dragged into this in the way that it's been done. But in any event, there we are. As to the second defendant, of course, there is a contract with the second defendant. There are contracts, but there's no case of breach. So they have to come to you and say, look, these are the terms that we say have been breached. This is our case as to what the terms were. This is what we say has been breached. This is our allegation of breach, and this is why the documents are relevant to that allegation. But they can't do that. They don't have that sort of case. There is a vague complaint, although we haven't heard it today, about the way in which the positions were closed out. By that point, the closed out is only the first claimant who holds investments in these funds, because as we saw, they were transferred from the third to the first. And the Abu Dhabi courts have already found that the second defendant was within its rights to close out the first claimant's assets in the way that it did. The reference to that is at Bundle C, tab 7, page 85. That's in translation. That's a claim the claimants themselves brought. They brought it to the Abu Dhabi courts, and now they want to come here and say, oh, well, there might be some other claim. I can't tell you what it is, but there might be one. So there's no way for my learned friend to satisfy that aspect of the test. I'm running out of time, so I'm going to have to deal with the rest of this as quickly as I can. Yeah,
apparently you got maybe 5 minutes.
5 minutes isn't going to be enough, I'm afraid. So let me do it like this. The jurisdiction agreement, there's a third problem with the application. There are jurisdiction agreements in favour of the Zurich courts.
Yeah,
we've got 10 subscription agreements, 2 credit facilities and 11 amendments. All of them have Zurich jurisdiction agreements in them, all of them. It's 23 different documents saying Zurich. My learned friend produces 4, which kind of, he says, come within that time frame and say DIFC. That in itself is very strange, but in any event, he has no evidence to support an agreement being reached on that. Miss Sheffield's evidence does not go that far. She simply says the documents were provided. There's nothing that could create offer and acceptance, such as to create a contract. The reference to her evidence on that is C59, paragraph 40.4. And that's before you get to the problem that she is not the appropriate person to be giving that evidence. She has no direct knowledge of those facts. And against her evidence, you have strong evidence from the third and fourth defendants and from an individual within the second defendant saying that was not agreed. So I don't have to persuade you today that it's a forgery. My learned friend has to show that how it is that he says that document is a contract. And then finally, before we touch on jurisdiction as briefly as possible, we've got the categories of documents themselves. In relation to that, the point to be made here is that it's not sufficient to ask for a broad range of documents on the basis that just some of the documents that fall within that range are going to be relevant and some are and critical, and some are going to be background. You can't expect the defendant or the respondent to sift through it all and say, oh, well, use your common sense, just produce the stuff that's really necessary. All of it has to be necessary. That's Sir David Steele's judgment in Hutchison 3G. You have that at Bundle I, tab 28, page 519. We won't go there now because I haven't got time, but it's paragraphs 38 to 40 and 44 to 45. And the critical part of that is that they need to, as I said, be able to show what the issues are and why it is that these documents are necessary to resolve those issues. And they can't do that because they can't tell us what the issues are. The second point, I don't know whether Your Excellency's picked up on this, the defence have already provided a lot of documents. On the 15th of August, they sent about 800, a little bit more than 800 pages of documents to the claimant.
Yes.
I beg your pardon? Yes, good. And they didn't respond to that until last Thursday. And what they don't say is, well, we've been through it all, and thank you for all of that. That answers X, Y, and Z, but we still need this. They just say, oh, no, we'll just carry on. And I think that just shows, that demonstrates that this is just indiscriminate.
Give me more. Give me more.
Yeah, I want more. For what end? It just makes it harder for them to establish. It's not even clear that they've been through the documents. And the third problem is that most of the documents are inter partes. That is, they're communications between the parties. So all the contracts are necessarily. Any documents containing advice, even though they say there wasn't any, necessarily are inter partes. So they would have them. And the fact that a party fails to keep records is not a good reason for pre-action disclosure. And there was a case brought by Jeremy Corbyn, who was the former leader of the Labour Party in the UK, and a case in relation to that. Again, I don't think we've got time to go to it, but it's at bundle I, page 829, and then paragraphs 21 to 22, and then 833 at paragraphs 34 to 37. And he alleged that there was an oral agreement, and he said, well, my representatives didn't take notes, but I think the other sides did. And so I want to see those notes so I can prove the existence of that agreement. And the court said, all right, you've got an issue. Those documents might be relevant to that issue, but for pre-action disclosure purposes, it's not a good reason to order that, simply that you didn't take notes. You could have taken notes. In this case, you could have retained your records. And then you come to the class of documents sought, which are 3. If we just go through them briefly, I'll give you my comments on the breadth of these, if I may, and hopefully that'll just take a couple of more minutes if you'll indulge me.
Draft order?
It's bundle B, tab 18, page 504. Now, in relation to some of these, they already have all that we've got. In relation to some of these, the evidence is that it doesn't exist. So bonuses and so forth, they just don't exist. But the rest of it is incredibly broad. So first category, documents which might assist in identifying the relationship. And then they want documents spanning 4-year period. Sorry, is that right? Yeah, 4-year period. And the reference to the document says relating to the onboarding of the applicants, relating to. So we've got to go through all of the documents that we control and identify which of them relate to the onboarding of the applicants as a vague and broad category. And there's no reason to think that it's going to shed any light on who contracted, even if there was an assertion of a case about that, which there isn't. That's the issue is answered by the contracts themselves, which they've got. Sorry, bear with me. I'm in the wrong tab, that's why.
You can go back, it's page B505.
Yeah, thank you. Yeah, I'm there. I apologise for that. All right. So then you've got what I have is paragraph 70. So it says for the period 1st of January 2013 to 2018, all documents recording agreements concluded. Well, they've got all of those. They've got all of the agreements concluded. 71 is extraordinary. It's all documents, including correspondence, emails, attachments to emails, letters, faxes, all records of meetings and telephone calls held between the applicant and the respondent, in which any of the matters in the evidence that says described above are were discussed. Yeah, I mean, so they've just recited the paragraph number. I mean, it's not actually clear when you look at the evidence what is being referred to within those square brackets. But it's an incredibly broad category. Any evidence of any discussions of any of matters, it's extraordinary. It's a search through, in this case, 6 years of archives for content identified by reference to subject matter. And one just has to think, what keywords are we supposed to use to look for those documents? How practically do we go about that search? It's extraordinary. And it's not going to shed any light on who contracted. The next one is about commission, and there was no commission, and the reference to the evidence for that is Mr. Lyons, paragraph 57, bundle B, page 473. Then category 2 is about identifying the professional services performed and the advice given. Well, rather like Mr. Corbyn, in order to rely on that advice, they're going to have to know about it. And so that's all inter partes stuff. The next one has us searching. It seems to be cut back, actually. perhaps it's the case that they've cut back the application in this draft order, because my notes were based on the witness evidence which recited the order. That's why it was fully there. So I had a paragraph. Oh no, I'm not. I'm wrong. Paragraph 73, which is the paragraph under the heading Class 2. Again, we're looking at 6 years of archives, which we say is just an unjustifiable, incredibly wide trawl for evidence. It's about trying to identify the professional services performed and the advice given, and circumstances when you can see the professional services from the contracts, and that there is an allegation that the evidence is no advice was given. And then the third class is about the employment status of the third and fourth defendants. My learned friend says there's a factual issue about that. That isn't. There isn't. There's no factual allegation. There's no case asserted that the third and fourth defendants were employed by the first defendant. And in fact, they've all the defendants have confirmed the employment status of the third and fourth defendants. They were both employed by the second defendant. Neither of them is currently employed by them. But you're asked for full disclosure of their human resources records, their personnel. I mean, it's just an incredible trawl that's being undertaken here. Copies of their employment contracts. To what end? There's no issue. An issue requires someone to assert something. There's no issue that would go to. So all of this would be a hugely expensive and time-consuming operation. And the first defendant has said they don't actually have any access to these documents. So that burden is likely to fall on the second defendant. The third and fourth defendants have their employment documents, or some of them. They have the contracts, I think, but they won't have the other stuff. And so you're asking effectively the second defendant, in the face of a jurisdiction agreement in favour of Zurich, to go off and do this massive, great big disclosure exercise. As I said at the outset, pre-action disclosure is highly unusual in commercial cases, and that's been confirmed a number of times. And there's simply no justification for it in this case. That's all I was going to say on the pre-action disclosure application. You've got my submissions on jurisdiction. I mean, I was planning to spend just 5 minutes talking about how it interrelates with what I've just been saying, but I appreciate it's getting late. Would you give me that time if I am 5 minutes?
Yeah, I will give you, but I have to go back then to Mr.
I understand.
Counsel of that. Yes,
All
go
right,
on
so
then, in this case.
Thank you. As I understand it, two central arguments are advanced on jurisdiction, although a variety of others are added. Whatever the test for jurisdiction, we're talking about territorial jurisdiction, not the power. Whatever the test, it's not satisfied just because my learned friend makes an assertion, which seems to be where his submissions end up. I try not to repeat the submissions, but I'll try to show you how it interlinks with what I've just been saying. So the first point is that there's a jurisdiction agreement in favour of Zurich, and I've been through those points. So whatever the underlying jurisdictional grounds under any gateway, that jurisdiction agreement needs to be respected. My learned friend agreed to it, and now his clients want to breach it by bringing claims in this jurisdiction. He says, well, we've got these other jurisdiction agreements. We haven't been through that in detail, but you've got my submissions in relation to that. There's no evidence supporting them. And even if they existed, they're interspersed through 33 other jurisdiction agreements in favour of Zurich. So they could only be either superseded by the next one or very, very narrow to their own terms. If this is a claim at all, it's going to be presumably a claim under the pledge or possibly a subscription agreements, but it's got nothing to do with the particular provisions that are identified in the undertaking or in these purported letters of guarantee. The undertaking is about redemption by the claimant of units in the funds, not about closing out by the second defendant. That's dealt with in the pledge. So what you've got is you've got this claim that's launched against these other parties in an attempt to justify a breach of that jurisdiction agreement. And you've got this necessary and proper party argument. I've shown you the authorities of that on that. The critical points to raise there is if you want to get within necessary and proper party jurisdiction, you can't just join any old DIFC entity, you have to show you have a claim against that entity. That's significant. And I set that out in my skeleton argument for the jurisdiction phase, paragraph 84, which you'll find at bundle F, tab 2, page 42. Otherwise, you're just inviting people to join any old DIFC entity as an excuse for bringing claims into the court, which is precisely, we say, what's happening here. Other grounds are advanced. My learned friend made an extremely loose factual assertion that lots of things occurred in either the DIFC or Dubai, which rather elides the point. To be clear, there is no evidence that anything relevant to the investments took place in the DIFC. My learned friend said, well, it's accepted that some of the shares in the funds were in the DIFC. You would take into Mr. Mackenzie's evidence in relation to that. If you read his evidence, it's not what he says. He's saying, well, it may be. He's not saying I accept it is. He's saying it may be. But what's that got to do with it? And my learned friend then took you to some schedules of subscription agreements and said, well, see that name there, that's a DIFC entity. So he was giving you evidence while he did that. There's no evidence to support that allegation. It's just my learned friend's assertion. But in any event, so what? Because the bank wasn't managing the fund. So if we're talking about performance of the agreement, the performance of the fund, the management of the fund is not a contract that my client is party to. Right? My client was simply providing subscription services, assistance with the subscriptions and loans. Those were the documents, those are the contracts that you can see. So there's nothing, if the test is a contract to be performed in the DIFC, what were the terms, what was required to be performed or what was performed? It was subscribing to shares in a fund that's outside the DIFC. None of that took place in the DIFC. Even if it were right, the fund has assets in the DIFC, completely irrelevant. So there were lots of other grounds advanced. You've got the single unitary entity point to try to combine D1 and D2, but I've explained why we say that's just specious. And then we've got the submission by my learned friend is skeleton. There's a considerable body of evidence of various other factors. He doesn't actually identify what that evidence is. He hasn't taken you to it today, and we say it doesn't support that allegation that anything happened in the DIFC at all. And then there's this argument about breach of DIFC laws. So you says, oh well, the DIFC court has jurisdiction over any tort claim under DIFC law. Well, that just has to be stated to be rejected. That's an extraordinarily broad submission. What about regulatory law? Well, even to get to a breach of regulatory law, you need to have some act that's occurring in or from the DIFC, and he can't get there because he can't. It just doesn't have a case on that. So that's all I was going to say on jurisdiction. But you've got my submissions in the larger skeleton argument, and if you don't already have a transcript of that hearing, we can obviously provide it to Your Excellency. Unless there are any questions. I know I've been longer than I hoped, but those are my submissions.
Well, thank you very much, Mr. Smith. I will turn now to Mr. Counsel for final remarks.
Conscious that it's late, and you've been very patient with us. So can I be very brief? I want to deal really with 2 points. One is the suggestions that Melenfra make about this now no longer being a pre-action disclosure application. And then secondly, his suggestion that I have to show a prima facie case, notwithstanding the authorities that we looked at last time and you made your decision on, particularly Total and Smith. So just turning to pre-action, this is of course a different regime from the English law, and your powers are greater than the English courts have under the civil procedure rules. And the starting point is DIFC court law, and the relevant one is paragraph 34, which you find in the authorities bundle right at the back at I-911. The DIFC court may, on the application of a party or on the DIFC court's own motion, require the attendance of any person and the production of any documents. And that's with respect to a very broad power, and it's reflected, isn't it, in the RDC rules, because as we've taken you to already, 28.55 makes it plain that nothing in the earlier rules, including 28.54, limits the powers of the court to order production of documents, and that's a reflection on what is set out in the DIFC court law. Whether it be by reference to 28.48 or by dint of the court's powers to order production, if it's in the interests of justice to do so, if it's necessary to do so for all of the reasons that we've been discussing, then, Your Honour, you do have the power to do that. And in fact, as a reflection of that, you'll remember that you were taken by my learned friend to one English case on that, which was the case of PMS, which is in your bundle in your authorities bundle. And I'm struggling to find the page the tab number now. If anyone can help, that would be very helpful.
Sorry, James, I missed that. What was what are you looking for?
The PMS case that you very helpfully.
Yeah. 26.
38.
Got it. 38. Thank you very much. And you'll remember, thank you. It's tab 38, and you were taken to I think to paragraphs 15 and 16. If you go over the page, Your Honour, to paragraph 19, what the court went on to say is interesting, in fact, because there's a reflection of it here from the second sentence. What if the application is made under Rule 3116 before the proceedings are commenced, but then the applicants commence proceedings before the hearing of the application, which effectively is where we are in this case? I consider that in such a case, the court would have jurisdiction under section 33 and Rule 3116 at the time the application is made, but doesn't under section 33 and 3116 at the time of the hearing. The court would retain jurisdiction to deal with the costs of the application. The court would have power under other provisions in Rule 31 to make appropriate orders for disclosure at the times when the court considers to be appropriate. So even in the much more restrictive English jurisdiction, that's a matter which can be dealt with, and you have that power, of course, under the RDC by reference to 28.56. The court may at any time request a party to produce to the court and to the other parties any documents that it considers to be relevant and material to the outcome of the case. And in this case, the only thing that's changed between now and when we were making this application on the previous occasion is that there was a need to serve or to issue a protective claim form. As everyone recognised, that was intended to be simply a protective claim form. It was not intended that the application should be, that the claim form should be proceeded with and particulars should be provided before this application was dealt with. And if there were good grounds, as we say there is, for all of the reasons that the learned friend and I have been discussing today, if there are good grounds for the making of an order for disclosure, then you still have the power to do so. And we say, with respect, that you should do that, applying the power that you plainly have, not only under the law, but also under the RDC.
Yeah, I see. Next point, Mr. Counsel.
Second point is the prima facie case. And in my submission, what we're really doing here is revisiting the issues that you were asked to deal with on the previous occasion. You have the cases of Total and Smith, and in my submission, you should apply those cases. And even if my learned friend were right to say, well, the claimants, the applicants need to articulate their case. Well, we've done so with respect in the documents and in the statements that you've seen from Miss Sheffield. And essentially, what this case is about is that these are allegations of negligence and breach of regulatory provisions regarding investment advice and products which the respondents provided to the applicants, and include a failure to carry out an adequate assessment of the claimant's needs and experience, a failure to provide suitable or sufficient information about those risks. And those failures, of course, include and perhaps consist of failures to do things, an absence of giving advice, a failure to provide that advice on the suitability of the investments, and potential breaches of facility agreements in the manner in which the margin calls were handled. And all of that is set out with respect in the documents which you have. And there were, what my learned friend then embarked upon in quite a lengthy passage, if I may say so, of his submissions, was doing precisely what one can't do at this stage, namely carrying out a factual inquiry into the facts and putting his own interpretation upon those facts. And he took you through each of them, but some of which he was able to deal with, perhaps you may think, better than others. And you'll recall when he got to the D110, the email from R2.
Yeah, carrying the letter from the board, the director of the board, yeah.
There's no explanation for that, and that rather gave the lie to the exercise that was being carried out. And he's doing precisely what you can't do at this stage, which is trying to carry out some sort of inquiry. The reality of the position is that the case has been stated, and jurisdictionally, it cannot be said to be beyond argument that there may be a case which the applicants will be in a position to put forward in due course. Just two very small matters, which he dealt with towards the end of his submissions. The all or nothing point in relation to the classes of documents, he referred to an authority which appeared to suggest, well, if it's all or nothing, you can't have some but not others. What he didn't take you to is an authority which is in your bundle of Hands and Morrison, which we've not looked at now. It's at tab 25 in the authorities bundle, and it's tab 25 of the authorities bundle. It's a case called Hands and Morrison, and at paragraph 29, what the judge did there was do precisely what my learned friend suggests one can't do. You see paragraph 29 on page 474.
Yes.
Next, the court must consider the discretionary question in detail, and that is likely to call for an examination of each of the categories of documents requested in any multiple requests, rather than just an all or nothing approach. So in an appropriate case, one can carry out that exercise. And the very last point, I'll just give you a page reference. My learned friend referred to it very briefly. It was the Abu Dhabi court proceedings. Ms. Sheffield deals with that in her witness statement, why those proceedings are different from these ones in paragraph 24, and the page reference is C54 in section C, page 54, if that assists. Your Honour, those are the points that I wish to make in response.
Can I just, Your Honour, can I just clarify one thing? Because again, my learned friend is mischaracterising my submissions. So I'm
about the email carrying the
about all or nothing.
Yes.
My point is that it's not that you can't look at 25 different paragraphs and say, well, 5 of them are fine and 10 of them are not. You can look at each individual paragraph, but everything that is called for in that paragraph must be necessary. That's the point. That was what I said. And that's what's being mischaracterized by my learned friend.
I think this is the test, is not relevant and necessary for every document. This is for the normal production of document test.
Yes.
Hey, I think I have heard lots and enough from you. for today.
Thank you very much, John. I'm
Doesn't
very
surprise
grateful
me.
to you for sitting so late.
Yes, yeah,
Yeah.
thank you very much. What I can say is that hopefully I can deliver this judgment before the Christmas. And I don't know if we didn't need, I mean, maybe cost submission.
Well,
I can deal with it.
You've obviously decided the stay application
And the privacy.
against my
Oh,
learned
both
friend
together,
and the privacy application too. So in principle, I would ask for my costs of those applications. There's no particular reason why that shouldn't be granted now. And the other costs need to follow the event, it seems to me.
Yes, I would ask Your Honour to put off the question of costs until we finally finish these applications one way or another, costs of the stay. There may be an argument, for example, that matters could have been dealt with without the need for a hearing on that application, and I'd need to take instructions on that. So I'd ask that we don't deal with any of the costs at this very late stage of the day.
I'll check further on this.
Yeah.
Yeah, I mean,
I know that my junior, Mr. Doherty, has been dealing with this. If you want to hear submissions on why you shouldn't make just an order for costs, then he's in a position to deal with that now, but it'll take a few more minutes, I'm afraid, to do that.
Say again, what's the point?
Mr. Doherty, who's poised, ready to deal with the costs issue if necessary, can make submissions if you'd like to hear them now as to why you shouldn't make the order that's being sought by my learned friend on the cost of the stay.
Well, I don't think I need to do this for now.
No,
I'll decide.
my principal position is you shouldn't deal with it now.
Yes.
we're in your hands.
That's for
obviously.
another. That's for
Your
another
Excellency.
day. But for now, I
Very good.
wish you a great day ahead. Thank you very
Thank you.
much.
Thank you.
Thank you, Your Honour.